new news is?
Go right ahead.
Okay. So we have been teasing for way too long, of course, a podcast. And we are finally going to be able to get serious about that. So I've got
2021. We were talking about it in
I mean,
2021,
5 years,
and,
5 years. What do you want?
yeah, and then I ran off to a couple people for years, and we had to set it up.
Oh,
Going
you're
back,
all Ship. You're all garbled up. Are you in the car? Did you hear me, Ship? King, is he all garbled up? Are you?
Yes.
Yeah, King, you're clear. Ship, say again.
I said yes, but only for about one more minute.
Okay. All right, good. Yeah, so it is true. We've been talking about this for a long time, but life happened. Ship started doing all those J6 cases, and then I decided to retire from practicing law actively, and we decided to move, and on and on and on and on. So, and there was kind of a lot going on in 2024. I don't know if you guys noticed that, but there was. So we are, in fact, going to be actually moving in the direction of doing this now. One of the reasons is because I'm sick and tired of this spaces business not being stable enough. Um, so I like this platform in some ways, and I don't like it in others. So what we're going to do is we're going to do a few more spaces to get people accustomed to, yeah, we're back in the mix. We're going to be talking regularly. And then for a while, a few months, we're going to be doing them at more like a real podcast over on Ship's Substack. So if you don't follow him over there yet, follow him there. I have an account over there. You may see me, but I only use it to follow, not to publish. So don't bother following me. It's not going to do you any good. Go ahead and follow Ship. Oh, I am going to announce it here whenever we're going to be putting up the podcast. So if you're only on X for now, um, or you don't want to join Substack, like permanently, you just want to know when we're going to be on there, I'm going to announce it here. And then we're going to do that for a few weeks while we get some other technical things in order. And also, Steve and I have some travel. And so in the late fall, we're going to switch over to a proper podcast, probably, which is going to be on Spotify. So, plus, King, I hate to rat you out, but we got to get King up to speed with some tech because here's a nice announcement. King is going to be on the podcast with us, so it'll be all three of us. And that way, if I'm traveling or if Ship is busy with cases, then there'll be at least two of us every time. So, King, you want to yell at me for saying that you're a dinosaur tech-wise, or?
Actually, no, I'm self-taught. Everything I do is self-taught.
Aha,
So I just give me a hat
right.
and uh some gear and
And
some
you're good to
books,
go.
and,
Point you in the
and
right
I'm good to
direction.
go. Yes,
Right.
that's it.
Okay. All right. So that's a little rundown. So by the end of the year, by the end of 2025, only 4 years later than what we originally suggested, we should be actually up and running a proper podcast. So bear with us for the time being. But in the meantime, we are going to be one way or another, either the Spaces or the Substack. We are going to be from now on regularly producing content. So that's good. Tonight, as usual, and this is one of the reasons why we want to get back to regularly producing content, is my God, there is so much going on, legal wise, law cases that are of interest to those of us on the right. And, we were going to talk about. We were going to talk about a whole host of things already, most of which falls on from last week. And we were going to talk about this new Massachusetts case. And then the DOJ hauled off today and sued the entire court in the District of Maryland. So it's a never ending stream of stuff at this point. So we're going to get serious about covering it for you guys. So I thought tonight we would run down the list of things that we talked about last time real quick. Some of these we're going to have nothing to say about, or a few lines. I can give you the update, and then we'll settle down to the more meaty stuff. So last week we talked about whether or not Senator Padilla should be charged based on his stupendously stupid foray in interrupting Kristi Noem's press conference. As of now, he has not been charged. So that's the update on that.
Well, I have
The
I have
other
one
thing we wanted to
I
talk
have one
about.
comment I want to add.
Okay.
I'm now coming around to the view that the public self humiliation of his crying on the Senate floor may
Crying.
be
Right.
eternal
Yeah.
punishment enough for what he did.
Right. Yeah.
That will
Well,
be the
it's just
gift.
so pitiful.
That will be the gift that never stops giving. So
Right, exactly. Right. You've Barbara Streisanded yourself. That was not so smart, Senator Padilla. Um, and so that's the situation there. Now, we're nowhere near the statute of limitations on that. And, he might, in fact, get basically MacGyvered and indicted later. So we'll see. So, switching to Congresswoman MacGyver's case, she had her initial appearance in front of the court today. Well, arraignment. She pled, shockingly, not guilty. And I took some notes. Let's see. The court set a status conference for August 8th, an in person conference, set some discovery and notice deadlines throughout the month of July, and set trial in that case for November 10th at 10 a.m. So while I'm figuring out what day of the week that is, Ship, do you know anything? That's in New Jersey. So do you guys know anything about how the docket is handled there? In terms of will that trial really go on that date or will it get kicked over or what?
I don't know.
Yeah. Ship, do you know anything about them? Ship, did we lose you? Well, possibly we've lost Ship. November 10th is a Monday. It is the second full week of November this year. So, what I'm talking about is that, Ship, are you there? I can see you and you're unmuted, but I cannot hear you at all. King, can you hear him?
He just dropped away.
Yeah, he's going to probably rejoin again. Okay.
Yeah.
So, what I'm talking about when he rejoins, we'll get his view on it, is in DC and Maryland, where I practice, the it's the courts here, the federal courts, don't set the trial dates within the first 70 days. I mean, that's what the statute says they're supposed to do, but the interpretation of the statute here has basically been if there's motions pending, if discovery is ongoing, if a whole bunch of other things, which are listed in the statute, then the judge doesn't even bother to set the trial date. And then in other districts, and California is like this, Ship and I talked about this many times when he first started taking cases in the January 6th cases. Ship, I'm sending you, I see you there, I'm sending you another co host invite. When he first started doing those cases, he was astonished at how the district court just couldn't be bothered to set a trial date because where he's from, they would definitely set a trial date within the 70 days of the statute. So, Ship, I'm talking about this trial date in Congresswoman MacGyver's case. Do you happen to know, are they more like California or more like DC in terms of holding to their trial dates?
I have no idea. I
Okay.
mean, I don't know anybody that's practiced in federal court doing criminal cases there,
Yeah.
but you may have mentioned. I could hear you, by the way. I
Okay.
was talking and you couldn't
We
hear me,
couldn't hear
so
you. Yeah.
I just came out. I left and came back. But I mean, you have commented, I think, that that the trial date set in November is outside the 70-day window.
Right.
I'm not sure what, if anything, was said on the record to exclude time. Sometimes what will happen, I've seen this in other courts in California, is that by setting a motions calendar, the judge then excludes time to and up to the date of the motions hearing or a decision on the motions, whichever comes later.
Right.
So, although that's not strictly the way the statute reads at any time during which a motion is pending shall be excluded. A lot of judges do just, set the briefing schedule and then exclude time during the briefing schedule.
Right.
So that may be just kind of the practice in New
Yeah.
Jersey that whatever that, the discovery is not a basis to exclude time.
Right.
But any time that motions are pending, and then you have the catch-all that to
Well,
afford
technically,
counsel.
discovery is not a basis under the statute, but in DC, that was what happened, right? The government would say, we have bazillions of documents to give them, and the defense would say it's going to take us months to review these, and the judge would say, fine, so we're moving the date. We're not
Right.
even going to
Well,
set
they
a date.
they wouldn't even set a date. That
Yeah.
was that. I think that is explicitly in violation of the statute. But
Yeah.
you're never going to
Yeah.
convince those judges. It's just the way they've
Right.
always done it.
Right. The docket entry says a continuance order to be submitted. So, I mean, this is just the minute entry that the clerk put on the docket today. So there's no transcript yet of what actually happened. But that little indication sounds to me like they discussed it, don't you think? That because if a
Right.
continuance order is to be submitted, the judge has to explain why the trial date is outside the 70 days.
Right. And typically, in some districts, there's just a practice where the government will submit the form of order and the judge just has to sign it.
Right.
And it's kind of boilerplate standard language, and oftentimes you have that catch-all provision about the interests of justice to afford counsel for the government and the defendant more time to prepare.
Right.
Yeah.
Right. And the next entry does say scheduling order the government to provide discovery on a rolling basis, blah blah blah. So that's probably what's going on here is that they have a ton of video to turn over to her lawyers and a bunch of stuff. So
Right.
yeah. So we're going to keep an eye on that, whether it'll go on November 10th or not, I don't know. But we'll see. And there's no motions yet, as far as I can see on this docket. So, very early preliminary stages, but unsurprisingly, this case is, at the moment at least, gearing up for trial.
I assume we're going to see a motion for absolute congressional immunity since we
Probably.
now have presidential immunity and judicial immunity.
Right. Yeah, the problem there is going to be that they kind of have a specific provision that applies to them already, the Congress, which has, interpretation applied to it by the Supreme Court already. So yeah, that'll be fascinating to see. Which is a nice segue then into the next case, which we're only going to touch on briefly tonight, which is this Wisconsin judge, state court judge, sought to have her case dismissed on immunity grounds, and the trial judge, what was that? When was that? At the end, after we talked last time, so within the week, last week, um, or
It
within the
was
last few days,
Wednesday of last week. There was a status hearing.
right? So the judge took that case off the trial calendar at this status hearing. It had been set for trial in July, I think, and the judge says, he's going to have to, I think it's a he, is going to have to rule on this motion to dismiss. I think the judge decided that that motion has more to it than maybe he originally thought, and wants to write something about it, write an actual opinion. And then the Wisconsin judge is almost certainly going to try to appeal that interlocutory, right? So I think
Right.
that,
And I think that is a situation. I could be wrong, but I think that might have been a district where their practice there is they set the trial date at the arraignment within
yeah,
70 days because the
right,
date that was set, I looked at the calendar, did the math, the date of the arraignment and the date of the trial date were 66 days apart.
right, very close to
So
the end. Yep,
okay, so that would okay, so it's within 70 days, so that satisfies the Speedy Trial Act. But then there's an exclusion of time when the clock is not running when a motion is pending. Well, she
right,
filed the motion on the day of her arraignment. In fact, she
right,
filed it before the arraignment. So that motion has been pending the entire time. So no days have run off the clock.
right.
And so the judge just vacated the trial date and said, time's not running, so I'm going to vacate the trial date. And once we deal with the immunity issue, we'll take up a new trial date.
Right, or something, or whatever, because they're definitely going to have to figure out this interlocutory appeal issue.
Right.
Probably the judge, like, there's no sense tiptoeing up to that trial date and then changing it later. You might as well do it
Right.
now, right? So, yeah, so we'll keep an eye on that too. And that's all fully briefed. I don't know if he's going to set a separate oral argument on it. I'll look at that more closely, and if there are more dates associated with that, I'll tweet them out once I figure it out, probably tomorrow. So Then let's see. We decided, didn't we, King, that there's no real update on Trump's removal case in the Second Circuit. That's going to be pending for a few months, right?
That yes, as far as I can tell, uh, it's now before the court to consider it and issue an
Right.
opinion.
Did,
So
did
we'll keep.
anybody did either of you listen to the oral argument in the E. Jean Carroll um,
No, I did
E. Jean
not.
Carroll defamation
I,
case in there? Not defamation. Well, I can't remember. Maybe it was defamation in
Whatever.
Second
Her
Circuit.
crazy
There was.
case.
I think he ended up with two Obama and a Biden appointee on his three-judge panel.
Oh, fun. There's so much going on. I can't keep track of everything happening in New York. I mean, so it's just too crazy. But yeah, when I get some time, maybe this weekend, I'll take a look at that, and we can talk about that next week if we want. Um, so the other thing we talked about last week was the Newsom suit in California. And so, Ship, I'll ask you, has there been any updates on that case?
Well, okay, so what had happened was, and I wrote a long Substack about this. If anybody's interested in going over and reading it, so you had I think we dealt with the Ninth Circuit reversing or staying the injunction issued by Judge Breyer, which was returning control of the
Well, we said
National
that,
Guard.
that's what they were going to do, and then like 2 days later, they did it. So we said, "Yay, we were right again."
Okay. Oh, you're right. You're right. You're right. That's what
Yeah,
we predicted. Actually, I think it was the next day. It was
yeah,
Thursday.
yeah.
It was Thursday that came down because Judge Breyer had already had a motion set for Friday. Okay. So what had
Right,
happened is at the same time he granted the TRO, he set a briefing schedule for the issuance of preliminary injunction.
right.
Then the
Which is
government,
not uncommon, so people
right?
know, because
Exactly.
the
Because
TRO is only supposed to, it's by law defined to last only a short period of time. And then the next thing is preliminary injunction. So
right.
usually, if you win the TRO or if you lose, the next thing the judge does is set it up so that you can roll right into the preliminary injunction hearing. So
Right. So
that's what this
typically
judge did.
the TRO will last 14 days, and then an injunction, if it's entered, replaces the TRO and lasts until trial.
Right.
So that essentially becomes it freezes everything in place until you have a trial on the merits and an outcome. Um, oh, I'm still there.
No, you're here. Yep.
Yeah.
And I hear you.
So what happened was, so Judge Breyer set that hearing the briefing schedule very aggressively. I think each side only had 2 days to prepare, and then he set the hearing 2 days afterwards. So he did that on Friday of the first week, which was right after Newsom filed his complaint, and then the hearing was set for Friday of the following week, which was last Friday, I think. Yes, correct, last Friday.
Yeah.
And then the Ninth Circuit proceedings all took place actually inside that window. The Ninth
Right.
Circuit briefed the case. The Ninth Circuit had the stayed his TRO that same night that he issued it, and then had a briefing over the weekend and an argument on Tuesday,
Right.
and then issued their decision on Thursday,
Right.
staying his TRO. And
Meanwhile, he and the other parties
but
are preparing for the preliminary injunction
well, each side had filed
hearing. Right. Yeah.
I think on Tuesday of that same week, when everything's going on the Ninth Circuit, the state of California filed a motion or a memorandum in support of a preliminary injunction. Now it does that at the time before the Ninth Circuit has ruled, so it essentially makes the same arguments that justified the TRO, but it added in a posse comitatus act claim, which it had not relied upon to get the TRO.
All right. So tell
So,
people what posse comitatus is,
okay,
because some people are
posse,
not going to know.
yeah, okay. So posse comitatus is a statute passed in 1870s. King, if I know I've looked at it, I think it's 18. But essentially, it makes it unlawful for anyone to use active duty United States military for the purposes of domestic law enforcement. So just simply to enforce the laws, arrest people, take them to jail.
So a lot of
Um,
people think that's in the Constitution, but it is not.
no, it actually is. It is a controversial limitation on the commander in chief's powers of the president. Congress steps in and says, well, yeah, you're the commander in chief, except you can't use the military forces to enforce civilian or civil laws or domestic laws inside the United States. So, but
Which is interesting because it makes sense in the post Civil War scenario, but at the same time, there was no federal police force at the time, right? There was barely a Secret Service, but there was definitely no FBI.
yeah, and I think
Yeah,
to the extent the United States Marshals existed, they existed only as an aid to the federal courts.
right.
Um, so, so the state of California had originally made a posse. Well, actually, I take that back. There is no posse comitatus act cause of action in the complaint. They raised it as part of their ultra vires claim, meaning that Trump's federalization of the National Guard was simply unlawful.
And
The
this was
one
one of the
claim,
reasons why, right?
right, and one of those claims was that the factual predicates for Section 12406 weren't met, which was the rebellion, invasion, and unable to enforce federal law, those three alternatives. That was their first claim, that because those factual predicates weren't met, invocation of the statute was unlawful. The second claim was because the orders did not go through the governor, that the invocation of authority was unlawful. And then the third argument was posse comitatus made use of the National Guard for law enforcement unlawful. Now, when they argued the TRO, the temporary restraining order, and Judge Breyer made this, asked both sides to state clearly for the record if this was the case. California did not assert posse comitatus as a basis for the TRO, and the government confirmed that they were not relying on the president's powers as commander in chief as justification for the federalization. So both sides took those two issues off the table, and I think it was, yeah, I
Temporarily,
think it was
because
just a
you can
matter.
do that. You can plead stuff in your complaint and rely on less than all of it for injunctive relief.
Right.
That's perfectly
They
acceptable
just weren't ready to go forward. I don't think they weren't ready to roll the dice yet on those two
on
claims.
that argument. Yeah,
So then Judge Breyer grants the TRO, but he does so only on the basis of, that the factual predicate for invoking the statute wasn't met and that the
the
orders didn't go
Insurrection
through the
Act
governor. Not
statute, not the
Insurrection Act,
posse
14,
comitatus. Right.
12406. That's not the Insurrection Act.
Right.
That's a whole
Sorry.
other level of
Right.
complication.
Sorry. I'm just trying to say it's not posse comitatus. You
Right.
keep saying the statute, but not the posse
Right.
comitatus
The
statute.
the 12406 just in aid of enforcement of federal law or unable
Right.
to enforce federal law.
Right.
So then that goes up to the Ninth Circuit. The Ninth Circuit rules in favor of the president and vacates the TRO. So now last Friday, the day following the Ninth Circuit issuing that hearing, Judge Breyer has the previously scheduled hearing on the preliminary injunction. It's relatively short. I think they were only in court for like 11 minutes. And everybody had digested the opinion for the Ninth Circuit issued the previous afternoon, and then there was just a short discussion about the the only live issue remaining for the granting of a preliminary injunction. So now we're not talking about TRO, we're talking about whether there's a preliminary injunction still to be had, is a violation of PCA, Posse Comitatus Act. It's easier to say. Violation of PCA. And so California had raised it in their motion for preliminary injunction, and DOJ had opposed it in the opposition. But both sides had done so rather perfunctory. I
Yeah,
think
they treated it
I
like
think
a
it was only
subsidiary argument. Yeah.
yeah, it was only 5 pages in California's brief and only 4 pages in the brief from the Department of Justice. So I think the recognition was, well, look, if either of you have anything more to say on this, supplemental briefing simultaneously due Monday at noon. So for the weekend they did that. Now he didn't set another hearing, so both of those briefs came in on Monday at noon. California, in addition to arguing for, there was a PCA violation, they asked for expedited discovery. They want to do discovery into the decision making behind invoking 12406, the instructions that were given to National Guard to see if they were instructed beyond what would be lawful with the posse comitatus restrictions, and they wanted to take a couple of depositions, and and so DOJ responded with a surreply to that started out just perfectly. It's like California has lost this case.
Right.
You know, they've already lost, and the weakness of the PCA claim is that the PCA reads that it has a provision that says except as otherwise authorized by Congress,
Right.
the military shall not be employed to enforce domestic statutes. Well, the government's position is, yeah, 12406 is one of those otherwise
Yeah.
authorized by
Yeah.
Congress
You guys
statutes.
notice this is a statute like written by the Congress people and,
Yeah.
like voted on by them and stuff,
And it was passed in 1905, so it comes
Right.
after the PCA was passed in the
Right.
1870s, post Civil War. So DOJ's response is the Ninth Circuit has already said that there was a sufficient factual predicate. The Ninth Circuit has already said that the process for sending the orders through the governor is not as literal as it was being read, and that it was satisfied. And the claim that the PCA has been violated ignores the provision of the PCA that says except as otherwise authorized by Congress.
Right.
So the government says there's no reason to do any discovery here. The case is over.
Case is over. Right. And so that's where it sits.
Correct. Waiting for either Judge Breyer to set a hearing or to issue a decision
Some kind
on
of ruling. Yeah.
some kind of ruling. So I can't imagine that he finds a PCA violation, but I didn't think he would go the way he did last week
Right.
either.
Exactly. We're
And
going to be mystified again.
Ship, what is California arguing constitutes law enforcement by the National Guard?
well, I think their argument there is relatively coherent. It is that the presence of the military to suppress violence is in effect enforcement of California law against unruly or violent behavior. It's it's the government can call it force protection or property protection, but that really is just preventative law enforcement. That's not an incoherent argument. I understand
No,
the
I
point they're
agree.
making,
I agree. And they're
but
also saying it's a fungibility issue. Like, even if you use the guards to do other things to free up more cops to be out on the street, that's still law enforcement.
yeah, but the problem is that the PCA authorizes this because Congress created a statute that says the president can federalize the National Guard for this purpose.
Does California address that issue?
No, they
What
ignore
what?
that.
Right.
That's
Yeah.
completely
Well,
that's
Yeah,
yeah,
completely
because
ignored.
they lose
Yeah.
on that ground.
I can't imagine how they would twist their argument into saying, yeah, well, yeah, the guard can be called up by the president, but they can't do anything because whatever they try to do to enforce the law would be law enforcement.
Exactly. So the
Well, one
and
argument I don't understand why they didn't make is this: Trump called the guard up in order to permit the feds to enforce the immigration law, right? Okay. To carry out their duties of doing the removals, right? And processing people and transporting people, and so on and so forth, which is not the same thing as suppressing a riot.
no, that's true. But I think both of them are authorized by 12406. 12406 says that the president cannot, with regular forces, or is unable to enforce the law. So you bring in the National
Right?
Guard to enforce the law. It doesn't matter. I think at that point, it doesn't matter
It
what they're
says
doing.
federal law. No, it says federal law.
Yeah, I don't have it in front of me. I think you're right. I
Yeah.
don't have it in front of me. Um,
Right. So I think he can absolutely use the guard. And in a minute, Steve has a question. So before we get off this topic, let's not forget to answer this question because it's a good question. But, the statute permits the president to invoke this and use the National Guard to enforce federal law. Okay, carrying out the immigration stuff is doing that.
right.
and protecting them while they're doing it is doing that from rioters.
Correct.
But when you shift over to, okay, well, they're not rioting at the federal immigration facility. Now they're just rioting in downtown LA generally. Now that's not what's going on. Nor did he invoke this power for riots generally. I mean, the government disavowed that they were invoking it for purposes of rebellion or insurrection or, public, just general public safety, blah blah blah.
But I don't think
So
I don't think factually there is evidence that they have used the guard for just general riot suppression. That George Bush did that
yeah,
in the aftermath of the Rodney King verdicts, when you had riots in that basically just consumed much larger parts of downtown Los Angeles.
right,
Um,
yeah,
but here, as far as I am aware from the coverage and what I've read, the National Guard and the Marines have only defended federal property,
right.
protected federal agents, and provided some ancillary assistance on enforcement operations. And I think all of those are perfectly within
Are well within the statute.
the
I
scope of the
agree,
statute,
but
right?
yeah, as I'm saying, California's better argument would be okay, but it's morphing into something else,
But it
right?
has, and that's what they
Right.
want discovery on. That's they want to
Yeah.
just kind of drag this out with discovery, but the discovery is just a fishing expedition.
Right.
It's like if it was happening, you'd think there's video of it happening.
Right. So two questions. Do Steve's question first, which is how long did it take Breyer to rule on the on the issues the first time? Is he taking longer now?
I don't know if Steve read my Substack, but that was a point
No,
I
he
made in
didn't.
the Substack. Breyer issued his decision, 36 pages, 3 hours after the hearing ended
Right.
on the TRO,
Okay.
which means his clerks had been writing that
Oh
decision
yeah. Oh, the
for
whole time. Yeah. Right.
for a day or more. I think the hearing started at 1:30. It went an hour and 10 minutes. I looked at all these details. The hearing started at 1:30 on this is on the TRO. Hearing started at 1:30. It went an hour and 10 minutes, and the opinion issued at 5:55 p.m. and it was 36 pages long.
Right. So he'd been working on it,
Yeah,
the whole time.
yeah.
Right.
So he had made up his mind before he took the bench what he was going to do. Now, on the PCA claim, again, just like we discussed, the PCA claim had been raised in the briefing papers leading up to last Friday's hearing. So it was before the court, but it was before the court in a kind of a perfunctory fashion. Now both sides filed on Monday, and here we are on Wednesday, and he hasn't done anything yet.
Still hasn't
So
ruled yet.
but
Right.
what he did do, I take that back. After California filed, and I think unexpectedly or surprisingly made a request for expedited discovery. Later that day, he ordered the government to respond to the request for expedited discovery. I think that was filed yesterday. So he did. There has been a little bit of delay while he asked for the government to respond. So he's working on his. I don't think he'll have oral argument. I think he'll just issue an opinion.
A ruling.
I have another question, and I haven't read the pleadings, but the California wants a preliminary injunction. The requirement for first requirement for preliminary injunction is irreparable harm. Now, I sort of got it when their argument was, look, you bypass Governor Newsom, and that's irreparable harm in and of itself if you're going to ignore the governor of a state. But here, if they're down to just the PCA claim, and which is basically, oh well, then you got the military out there enforcing our laws. What's the irreparable harm of having more people enforcing the laws than should be? I mean,
Well,
what is their argument on that?
yeah. This goes back to the original TRO. The first argument was for the TRO, and Bayer bought this and wrote it into his order, was that the governor was deprived of 4,000 National Guard troops that would otherwise be available to him to fight wildfires and other kinds of potential
All of
disaster
California's
relief
other problems.
situations in California. Exactly, and ignoring the fact that June is not wildfire season. Wildfire season in California starts in September after long hot summers dried everything out. Then you have the wildfire season,
Right.
not when the snow is just finally finishing melting. Um, and but the Ninth Circuit didn't really address that at all. They simply didn't find on the ultra vires claim that there was anything unlawful. Um,
That
and
that they had another argument that I think is the one they probably pushed the strongest, which is they claimed and wanted to put on evidence to show that the mere presence of the guard on the streets of California uh, triggered the
Oh,
rioters
so
and made
intimidating to people. Yeah.
and made it worse.
Right.
and in fact, Breyer included a reference in his order suggesting that by saying that potentially it would potentially be a calming effect to remove the military presence from the streets of Los Angeles.
See, isn't this like a completely fascinating perception issue? I think depending upon whether you're on the left or the right, that argument makes sense or is completely absurd.
Right. Well, I mean, the violence wasn't caused by the military. The violence was
No.
caused by the ICE operations. It was a reflection or a manifestation. Well, I mean, it was not organic. It was all
Yeah.
bought, paid for.
Right.
Yeah. Something else that strikes me that came up today, that in response to the request for discovery that California filed, or that the Department of Justice filed yesterday, they asked that the case be transferred to the Central District, and they called out California for forum shopping.
Right.
All of these events, all of the people involved, all of the activities, all the discovery would concern matters happening in downtown Los Angeles in the Central District, and the state of California forum shopped this to file it in San Francisco.
Right. Because they thought they'd get a easier hearing
Right.
from any judge there. Yeah.
Right. So the DOJ called them out and said, if the court is inclined to grant discovery, then the court should transfer the case to the Central District of California, where everybody is.
Where it like belongs, actually. Right. Steve's laughing at this. Yeah. All right. So we will be keeping an eye on this to see what Judge Breyer decides to do. What do you think, that opinion will have clipped his wings at all?
I think the government's point in its filing yesterday, he probably is going to likely concede to, which is, California's lost this. I think we were all of the opinion this wasn't a serious complaint when it was
To
filed. It
begin
was an
with. Right.
attention.
Yeah.
It was an attention-getting complaint, and the fact that it lasted this long. But I think Breyer understands, if he finds a PCA violation and orders a preliminary injunction, it's the same three-judge panel that just reversed him that's
Right.
going to get it back.
Right. Right. And that's obviously not going anywhere. So,
Right.
yeah. Right. So I've pulled this statute up finally. So it is, as you say, it is not the Insurrection Act. I want people to be clear about that. It is, in fact, the statute that talks about the president's power to federalize the National Guard. So this is in Title 10, Section 12406. And the language of this third section that they were relying on is that the president is unable, with regular forces, it says, to execute the laws of the United States. So that's not, in statutory interpretation, that's not going to include the, trespassing and assault laws of
Right.
California.
But it would include protection of federal property,
Right. And buildings. Right.
and
Et cetera.
protection of federal personnel in the performance
Right.
of their duties.
Right. Exactly. Yeah. So, okay. All right, you guys. So shall we turn to these other two cases, which is where we wanted to spend the bulk of our time tonight, I think. Anything else we want to talk about these other ones or say? Oh, I have one comment if you guys don't. But I'll let you guys go first. Anything else?
Not for me.
Not for me.
One thing I wanted to say about this Newsom case is Barb McQuaid, one of our favorite, and I use that ironically, lefty legal people, on Twitter is she scoffed at the government's argument that failing to put this through the office of the governor was what the DOJ lawyer called a foot fault. Oh, she just went totally off on that, saying, it's that's just not far from a foot fault. This is like a blatant, violation, fundamental, and all of this craziness. And so I laughed so hard when that Ninth Circuit opinion came out, basically saying this is a big nothing burger that they didn't technically send this to Gavin's office because under California law, the commissioner there is his agent, and since it went through the commissioner, or the commandant of the guard, that's effectively sending it to the governor. So this is 100% a big nothing burger. So I really thought that was humorous because it's another example of how often, not always, and not all of them, but a lot of these lefty lawyers and analysts, they don't actually delve into the nitty gritty of what the local law is. She's from Michigan, right? She's not a California lawyer, so she's not able to evaluate the actual strength of that argument because she doesn't bother to do the deep dive.
Well, it's interesting. The Ninth Circuit did a little bit of a semantic analysis of that. They didn't spend
Mm-hmm.
much time on it, but they did say that that the phrase "go," the orders shall go through the governor is
Yeah.
not the equivalent of saying the orders shall be by the governor.
Right.
So
Well, we talked about there's good reason for that, history shows. Sometimes the governor is, in fact, the problem,
right.
right? When you're trying to enforce federal law. So, yeah. But I just thought that was interesting that she totally scoffed at this foot fault argument, but that was the right argument by the government. That was a foot fault. It wasn't even actually a fault at all, you could say, since they went through the commandant. But anyway, okay, so let's do, which case do you guys want to do first, Massachusetts or Maryland?
Well, I wrote a long article today on Massachusetts, but
Yeah.
I have only just sort of briefly skimmed the whole Maryland issue. If you and King have looked at that more closely, I'd leave that one to you.
Okay, let's do Maryland first then, and then devote the bulk of the time to Massachusetts, which is more complicated, right? King, did you have a chance to look at much of this stuff in Maryland today? Do you want to explain it, or do you want me to? King, you got to unmute yourself.
I've read it and never seen anything like it.
Steve's laughing
It's
too.
it's crazy.
It's crazy.
The United States of America and the United States Department of Homeland Security they're the plaintiffs, and the defendants are Chief Judge George Russell, Judge Adam Abelson, Judge Richard Bennett, Judge Catherine Blake, Judge Deborah Boardman, all of the judges in the United States District Court, District of Maryland, plus the clerk of that court.
Plus, somehow the district court itself, which I don't know if that's a suable entity, but they
Yeah,
added it anyway.
just it's a belt and suspenders, I guess. uh, they sued the United States of America, the government, the one with the big bunker busters. They have sued these judges for entering what's called a standing order.
So let me ask King, let me stop you there. Were in the courts where you practiced, did they have standing orders much at all or none or a lot?
Occasionally, but when they did, they were hilarious. I could give you some examples. Uh, these standing orders are basically procedural add-ons to the local rules of court that govern how the court is to act in criminal and civil proceedings, letting all the lawyers in the town to know, what to do and when, and how many pages you can put in your brief, and what font to
Yeah,
use,
right. That's usually with the
etc.
local
Just
rules. The standing orders are usually
all
more
the
administrative,
yeah,
right?
all the
Yeah.
mundane rules you got to
All the
follow.
anal retentive shit that you have to do when you're a lawyer.
That,
So,
that's right.
Ship, let me ask you, where you practice? A lot of standing orders or not so many?
Well, I've only seen standing orders of individual judges.
Mm-hmm.
I've never seen a standing order that was district wide, because a standing order that's district wide is simply a local rule.
Right.
And this is one of the issues raised
Yeah.
in the complaint, is that the court has evaded the procedural requirements for adopting local rules, which are written in a statute.
Right. So I practice, as I think most folks know, in Maryland, DC, and Virginia, in the federal courts. And all of them use standing orders quite a bit. I would say Virginia probably the least, then DC, but Maryland uses them a lot. And the ones that they issued during the COVID were kind of crazy, just like flat out crazy. Okay. Um, but the it is pretty common in that district, and it's normally like the COVID ones were, sort of administrative, part of helping the courthouse run, efficiently, which is part of the problem because then the judges kind of overuse them sometimes to make their lives easier, but that often has the effect of making the lawyers' lives more complicated. So,
I thought we had a No Kings weekend last week.
oh my goodness, right? That, well, Judge Russell didn't get the message, so he wasn't on that memo. In terms of,
Let me give you an
oh, go ahead.
example of a real standing order that happened back in the 1970s in a district I practiced in. Uh, there was a very high profile federal grand jury investigation into uh, labor unions, corruption,
Mm.
and uh, with mob ties. And the Teamsters, which was one of the targets of the investigation, uh, some of their uh, members kind of hung out in the courthouse on the floor,
A little
on
witness
the floor,
intimidation going on there.
on the floor where the grand jury room was, watching people, staring,
One
at
might even
people
say
as
gauntlet
they
like.
came
Is
and
that
went.
what you're saying?
Yeah, and the chief judge came, whose office was on the same floor, came out of his office, and there were all the Teamsters sitting on the floor,
Mm-hmm.
sprawled with their legs sprawled out
Mm-hmm.
halfway across the hallway,
Right.
blocking the hallway, staring down grand jury witnesses.
Right.
And the judge got red in the face. I've had 2, 3 people describe this
Mm.
to me who were there. Got red in the face, didn't say a word, went to his office, and inside of 5 minutes had a standing order running everybody,
Let me
who,
guess. This
who
is a literal standing order.
a literal standing order running
We're going to
everybody
be here all
off
week, you guys.
off of that floor.
Thou shalt not sit on the floor in the courthouse.
Just sit. You can't even show your face on that floor
Oh,
unless you carry a subpoena,
right.
or you
Or a
are a
badge.
witness
Right.
in a
Right.
court.
Right. Oh, that's hilarious. Right. So this is typically what the standing orders are about, running the courthouse, right? Which is why they don't go through the normal comment procedure for a local rule, because they're not about the cases. They're about the courthouse, right? But as I said, the Maryland district has kind of gone crazy on this, and so there are standing orders on all kinds of stuff. And when you practice there, and you like join there, or you pro hoc or whatever, you have to swear up, down, and sideways that you've read all of the standing orders that apply to your kind of case or to the courthouse generally, right? It's really nuts. But anyway, I mean, when I was in law school, I thought you had to know the law and you had to know the rules of civil procedure or criminal procedure. And then pretty much you would have a good grasp on what the law is. But that, of course, that turns out not to be true at all. Also, allegedly, the federal courts have uniform rules that are the same across the nation, except that hasn't been true for forever because every court, region, circuit, and then sometimes district, and sometimes division within district has its own local rules, and you have to know those too. And then they'll also have, DC's famous for this, so Ship, you can comment on this. They'll also have their internal operating procedures, which you're also duty bound to know and understand and have a good grasp of. So, to take one case in a courthouse, you got to read 500 pages of rules and shit. Um, and then in addition, you've got these standing orders. And then, as Ship says, often a judge will have his or her own standing orders that apply to criminal cases or civil cases, blah, blah, blah. So, what this court has done, issued under the signature of the chief, and I don't know, I haven't seen any articles or interviews or anything that have said yet whether all the judges got together and wanted this, or whether Judge Russell, who's the chief, just thought this was a good idea or something. This new standing order says that in habeas cases brought by immigrants, so it's applying to a class of case, that there will be an automatic stay on them, removing them, for 48 hours until basically the judge can get a handle on the case. So go ahead, King.
Yeah, it's more than a
Yeah.
stay. It's the actual temporary restraining order or some form of
Injunction.
injunction, and
Right.
it's automatic.
Right.
No notice, no opportunity to be heard by either side. The only thing that happens to trigger this injunction is the filing of a writ of habeas corpus by an immigrant who claims he shouldn't be detained or shouldn't be detained and sent out of the country. So,
So
so
basically, when the clerk gets the civil cover sheet, which is another thing lawyers have to deal with, you file your lawsuit, and then you also have to file the civil cover sheet, which is a form that tells the clerk what the case is about, because of course they can't bother to read your complaint. You have to fill out this form that tells it to them in a format that they want. So presumably, right, the clerk's office is going to get the civil cover sheet, see that that's what kind of case it is, and wham, bam, you're going to get your TRO.
and then a notice of that TRO is sent uh, electronically to somebody.
To
Somebody in the
nobody at that point because the government hasn't even entered their appearance yet.
no, but
No, no,
they
no,
they
no. The
de-
rule provides that the filing, the notice of the cover sheet, and the standing order shall be sent to the civil chief of the U.S. Attorney's Office of District of Maryland.
that's it. It
But
it go
by mail, by email, but I thought you
By
were talking about
email.
the
By
ECF. Oh,
email.
by
yeah
Yeah.
email.
yeah.
Okay. Right. Okay. Well, that's what I mean. I was talking about the ECF. So for folks that don't know, ECF is shorthand acronym for the electronic case filing system for the court. So until a lawyer enters their appearance in that case, they don't get the notices or anything. So yeah, in order to make this work, they're having to make the clerk do an extra special step of literally emailing this to the government.
Right, but there's generally each U.S. Attorney's Office has kind of a default
Yeah.
ECF address, so they get everything that's filed in any case, not just the individual lawyers on the case. The office itself gets everything, but the standing order says shall email to the civil chief of the U.S. Attorney's Office the standing order, the new case, the name of the defendant, basically telling them the standing order is in effect for this case. Don't violate it before they, before they've done anything, before they've got anybody assigned to it. But
But
that, King, I think you're going to go into this, so I'll let you go into it. But that creates some operational difficulties for ICE.
For the government. Yeah. Go ahead, King.
it uh, they tried to be nice to the government because it only lasts 2 days.
Right.
So the government at the end of the 2 days, the court can either extend that injunction or let it lapse. and presumably within the 2 days, the government will raise its head and ask to be heard about whether it should be remain in effect or not. That's the concept of this crazy order.
So two
Uh,
things. One, as a practical matter, it's definitely going to be longer than the 2 days, right? Because even if the government objects to it within 2 days, I'll be hard pressed to think that you're going to get a ruling from any judge there in 2 days. But the other thing is that don't we think, do you guys disagree with this position that this is an attempt by the court to prevent the government from deporting people before anything has been litigated in front of a judge, because they're recognizing the point that we've made in multiple of these spaces, that until there's an order telling the government you cannot deport this person, the government has every right to follow the law as it understands it. That until there's an order from a judge in place, there's no order from a judge in place. So this is trying to put the order in place up front, and then the government has to ask pretty please for the order to be taken off.
Well,
Yes, it is. It is in effect creating an obstacle to the normal
Right.
functions of ICE.
uh,
You know,
uh,
once a defendant, once a deportee, let's say a defendant, once a subject has a final order of removal, the wheels go in motion.
Right.
And so what this is doing is they've created a standing order, in essentially inviting filings in Maryland.
Right.
Just file a habeas petition in Maryland, you've got 48 hours.
well, but
Uh,
all right, but a couple of things. I mean, I agree with you that it's an obstacle. I agree also that it's sort of unheard of because it says that a lawyer that files a lawsuit automatically has a 2-day temporary restraining order. We don't do that for any other case in the federal court system.
Literally,
No,
no
no, no,
other
no.
case.
So I've got big problems. But to play devil's advocate for just a second, didn't the Supremes say that when you're going to be shipping these people overseas, you first have to give them an opportunity, a meaningful opportunity to get a habeas on file? And couldn't, if I were going to defend this order,
Mm.
uh, I'd say, how is this anything other than a practical manifestation of what the Supremes have said has to be the way things operate?
wait,
Well, the
wait,
counter
wait, wait,
argument would
wait,
be
wait.
that
That
wait,
wait.
wait, 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 wait. The counter argument would be that law already exists. You just told us what the Supreme Court said, and so if the
No, that's
government
not the counter argument.
doesn't do it,
The counter argument is that is only in the context of the Alien Enemies Act, where somebody has been brought under the umbrella of that proclamation and has got no opportunity to say, no, no, I'm only 13 years old.
right? Okay,
That's
but
why they have
even
to
in
have an
that,
opportunity.
yes,
These are this
but even in
applies.
that situation, the Supreme Court's already said that's what the rule is. The district court doesn't need to be setting up procedures. The government's supposed to be following the law.
Right, but that has followed the law. These cases have worked their way through the
Right.
INA procedures. An order of removal has been entered, and the wheels are in motion for this person to be taken to a point where they are going to be deported.
Right.
Then a
Okay.
habeas case gets filed
Right.
that may have zero merit, and
Right.
in fact, because district courts don't even have jurisdiction over,
Almost
and
all of it. Right.
this is interference. This is interference with the removal process, with the enforcement of the order of removal. That is one area that is explicitly excluded from district court interference,
Right.
is interfering with the execution of an order of removal.
Okay. Okay.
So,
So
so
slow down.
now,
Slow down. Slow down. But slow down. But first, I was responding to Steve's point that you could defend the standing order by saying, well, the Supreme said some of these people have a right to have this kind of sort of timeout.
only the AEA people,
Right.
nobody
Okay. But
else.
let's assume that for sake of argument, that the standing order could be modified to only apply to them. The counter argument still would be you don't need this standing order because the law of the land, as explicated by the Supreme Court, says the government has to give them that opportunity. So this standing order is a nullity. It's not necessary.
I agree. It assumes unlawfulness on the
Right.
part of the government, and
Right.
yeah,
they have to assume that the government, there is a, I think the law requires an assumption that the government will act in compliance with the law. Now,
Right.
that's not always
And
true,
that's not,
but
obviously, that's not what the judges think they're getting, right? That's
right.
why they've decided to create this standing order. King, what were you going to say?
Another reason I think is they want to take more vacations.
The judges. Yeah.
They don't want to give to have a judge standing around to sign a TRO upon the filing of somebody. Right now, the federal rules give a detainee all of these rights when they file with proper jurisdiction, a writ of habeas corpus. If they if they show good grounds for this kind of TRO, as Ship explained, under certain circumstances, the Supreme Court said they're entitled to certain rights, and if those rights are being denied them, they can file their habeas uh, and take that filing to the local judge, ask him to sign the TRO right there on the spot if they can find the judge. All this does is make it automatic, and you don't need a judge in the in to hang around to
Right, the
sign these
clerk is
things.
going to do it because
Yeah,
that's the purpose of the standing order, is to
Right.
foist it off on the clerk. This is what I
correct.
was saying before, is that it's a lot of times these standing orders is to make the judges' lives easier, so everybody else has to do the work except them.
Okay, so and there's two other aspects here that I think are worth. This is in some ways a response to what I would say are some aggressive practices by DHS and the Trump administration. They
Right.
are
Oh,
doing a
more
lot
than
of this
one
stuff.
judge. Yeah,
They are
more than
doing
one judge has said on the record, you are basically playing games with us. You're sending these people out after we told you not to.
no,
That
no,
was
they're doing it.
Boasberg's problem, blah,
They're
blah, blah. I don't agree with that, but that's what
Stacy,
some of the judges obviously think.
yeah, but they're doing it on weekends when they know the courts are not in session. They're doing it after business hours, and they're
Right,
doing it with very little notice to the deportees. So there's no
right.
opportunity to set in motion even anything even anything that would be legitimate. They're and now, but by the same token, those practices are being used in recognition of the problem, which is they got 20 million people to deport because of
Right,
what the Biden administration did.
right, right.
And they don't
And
have any
they've got these
process.
very aggressive plaintiffs' lawyers or deportee lawyers, immigration lawyers, who are running to the courthouse now in cases where the court doesn't have jurisdiction.
They just get on the email. They don't even have to. No, okay,
Right.
so now this is another aspect though that's raised in the complaint that I hadn't thought about. And I just mentioned it briefly a moment ago. One of the problems that the government's highlighted is this is an invitation to people all over the country to file in Maryland, even though you're only supposed to file habeas in the district where you're held. Because
Right.
you get 48 hours whether you're in Maryland or not. Until somebody figures out and establishes in record that you're not in Maryland and you shouldn't have filed in Maryland, you get the benefit as if you are in Maryland. And so, and that is even there. The government has even pointed out that they have instances where third party friend ofs who don't even know where the defendant is are filing in Maryland.
Right.
And then DHS points out, and this may have been in the complaint, that DHS isn't even housing people in Maryland because they don't have room for them.
Right.
So why are people running? So
Maryland
now,
is a small state
Maryland,
geographically.
yeah,
Right.
it's making itself. The District of Maryland has made itself a sanctuary court.
Yeah.
If you want protection,
Right.
just file here. We'll
Just
sort it
run
out after
run to
4 days.
Baltimore. Right. Okay.
Yeah.
So on that point, since I am a Marylander, lived all my years growing up in Western Maryland, I will say people often say, "Oh, well, Maryland's a blue state." So let me address this. Maryland is only a blue state in the middle third. Okay.
Most of the people live.
Where the most of the population of Maryland is. Okay. The eastern third of Maryland is red. The western third of Maryland is red. Unfortunately, it's 2/3 of the geography, not 2/3 of the people. But
Right.
the district court, there's two divisions of the district Court in Maryland. One sits in Baltimore and one sits in Greenbelt, which is in Prince George's County, which is one of the counties that's next to the District of Columbia. And so almost all of the judges now in the Maryland District Court are pretty liberal, or they're, I would say, moderately liberal. 20 years ago, it was a better balance of conservative and liberal judges, but now the judges there are pretty liberal. So this is what's going on. It doesn't shock me at all that the District of Maryland is the district that decided to do this.
Yeah, and because it has become a go-to filing point. District of Maryland. There was a stat that came up a couple of weeks ago. I read District of Maryland, District of Massachusetts, District of Columbia, Northern District of California, and Western District of Washington are where like 70% or 60% of all of the cases against the new Trump administration have been filed, and where 90% of the injunctions have come from those five districts.
Right. All right.
Now,
So King, do you want to tell us what the causes of action are in the complaint? So
they,
the DOJ sued all these people for what?
they uh, before I do that, there's one aspect to this that as the government describes it, the 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 government views this as sort of a chess move by the judges in this court because it kind of blocks the government's queen. They point out that because it's of limited duration and even if extended can always be dissolved along the way. Effectively, it it reduces the ability of the government to appeal this because it's going to end up being moot. The
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 standing order itself, right?
the standing
And the
order by
48
its
hours. Yeah.
the 48 hours it creates a situation where whatever harm the government may have suffered is over and the case can move on in under regular procedure.
And they could
So
never get review of it
and
effectively.
then never get it reviewed, and it's just a like sticking sticking a stick in somebody's bicycle spoke.
Right.
Uh, count one is, which is the one that jumped out to me, uh, the most obvious. Uh, it violates the statutory and federal rules of procedure requirements to get an injunction. You have the plaintiff has the burden to show things like irreparable harm. The
There's a
court has
test.
just
They have to
yeah
satisfy the test. Yeah.
that
Now
and
there's no test. You just show up and file.
right. It's an automatic thing. So
Right.
that's count one. Count two is let me
That violates the rule, isn't it?
see. I'm trying to scroll through it. Hold on.
I think count
Uh,
three is violates the rulemaking procedure.
count violation of jurisdictional bars is count two,
Yeah, that's right.
which means uh, you've got statutory jurisdiction within the agency, the under the Immigration and Nationality Act, and this kind of cuts through that and creates basically primary jurisdiction in the District of Maryland. Uh, and then count three violates the requirements that the local rules have for uh, getting rules with general applicability uh, to be approved. You have to send it to the Fourth Circuit Court of Appeals.
Right. There's a whole
It has to
committee.
go to
Right.
you have to go to a judicial conference. It has to be an advisory committee gets to look at it and comment, etc. They bypassed all of that with this, um, which I think brings up the fundamental issue: can the government sue judges?
Right. I know. We're going to get to like the procedural issues of it because there's a whole bunch of them. But these three counts struck me when I first read it because these are all counts in equity, meaning they're not law counts. It's not like breach of contract, right? And they're not statutory violations either. So this is fascinating to me. I don't know if I've ever seen a case, Steve, have you, where the federal government is suing and all of the counts are equitable? He's thinking. Well, he's thinking. I'll say the government in its complaint has a
What?
section explaining that it has equity rights and for explaining why this is.
But who has jurisdiction to decide it? You've got how many district courts in the federal system? Um, I forget the number. Used to know it. Help me.
Didn't we say 93? There's 93 districts. 60?
Nine. That sounds about right. 93 different districts. They're asking all of the judges in Maryland to be recused because they're defendants. So they have a conflict. So they're asking a judge from somewhere else to be flown in to decide this, uh, as standing in as a temporary judge for the uh, District of Maryland. And I've raised that because generally a court in one district is not going to interfere with or overrule or act as an appellate court for something a uh, sister court somewhere across the country, say,
Right, court on the
has
same
done
level. Hmm.
on the same level. They don't they don't do any. They avoid doing anything to interfere with courts that are on the same level as the first one. And here, basically, the government is asking some other district court, district judge from somewhere come in and decide that the Maryland judges have violated the law and their standing order should be stricken.
They
Uh,
filed a motion separate from their complaint where they asked for this, what they're calling a transfer. So they asked for all the judges to be recused from this court because they're all sued, they're all defendants, and for the clerk's office, which is also a defendant, to coordinate with the Fourth Circuit's, because Maryland is in the Fourth Circuit, the Fourth Circuit's clerk and administrative person to use the normal procedure, which is in a case where all the judges in a specific district are recused for some reason, which doesn't happen very often, but they have to have a procedure for if it does happen. So now here we are. Um, they then solicit the clerk's office without even consulting the Fourth Circuit judges, apparently. They have a list of judges that are available. They're probably mostly retired or senior status judges to take over a case where none of the judges in that district can sit. And then a judge who accepts that assignment, then the circuit judges agree to order that person to take over the case.
except the normal procedure, everybody has to recognize, is if a particular litigant is unhappy with something the lower court did, you either appeal it or seek interim relief by writ of mandamus or some other writ to the at the appellate level. You go to the Fourth Circuit.
Well, but normally you have to ask the judge you're in front of to make a ruling first, and that hasn't happened here, right?
Well,
So,
the judge has already made a ruling that you've got a standing order,
standing
and they
order, right?
and the government says in its complaint that this standing order has been applied in a number of cases already. So there are cases on the docket where it's been applied, and the government's done nothing to object to
Appeal
that
those.
at the appellate level.
Right. Because they're going to run into the problem you identified, which is they're going to be told, well, that issue's moot because that 48-hour TRO has already been voided in favor of something else.
Yeah, but I think
So
that's right. I think that's a wrong answer, though. I think
I
this
do too.
this easily sets up for capable of repetition but evading review.
Right.
They should just raise it in one of the cases on interlocutory appeal and challenge the Fourth Circuit to take this up.
Right.
And
But
that's
that's
why I
not
think
what's
in
done.
some ways, this complaint is a little bit of a stunt. I don't think anybody really expects this complaint to proceed to a merits determination in any respect on any of the three causes of action. I think
You
it's
think, to use the baseball term, it's a brushback.
Yeah, it's intended to get the presiding judge of the Fourth Circuit to pick up the phone and call the presiding judge in Maryland and say, "You guys need to stop this for all the reasons identified in the complaint."
I mean, they could have done that on the first week
Well, but no, no,
with a
no, no,
writ
no,
with
no. Oh,
with a writ of mandamus
well, yeah,
into
yeah,
the First
you're
Circuit.
right. But this is, I think, in many ways, an actual manifestation of the ongoing fight between the Trump administration and district court judges.
Yeah, I think so too. Right. So
and
procedurally,
that and
is
that
it the
district in
correct
particular.
maneuver? Maybe, maybe not. Because as we all saw in General Flynn's case, if you file a mandamus, there's a lot of ways the Court of Appeals can tell you you're not entitled to a mandamus and you got to go back to the district court and get a ruling from them and see it later. So maybe they didn't want to run the risk if they tried to mandamus it now that the Fourth
No, I
Circuit
mean,
would just fool around with it.
I don't think that argument could apply. I think the worst thing that could happen to the government would be rejection by the Fourth Circuit on the grounds of mootness. But if you've got a whole carload of these things, uh, take them all up at the same time. The problem with I can't see the appellate court saying you don't have a ruling from the lower court, because you do. You have a standing order
Yes,
that's
but it
being
might
applied
not
in
be.
every case,
Yes,
every habeas case that gets filed, and
yes, but
now
it's still
they're
it's
multiplying like bunnies.
yes, but it still might not be subject to mandamus because of all the picky little rules about mandamus. This is what I'm saying.
Right, but
So
that's why I would take it up on an interlocutory appeal and force the Fourth Circuit to either say no, or force Fourth Circuit to call the call the district court out, or say no, in which case you take it to the Supreme Court.
right, exactly. So what they've done is they've filed suit saying that this standing order is unlawful on equity counts. I want to get back to that because King, you didn't answer my question. You wanted to talk about the procedure, so we'll do that first and come back to the nature of the counts. But so they have filed suit instead of either appealing in the cases where it's being applied, or filing for a mandamus or some other kind of writ in the Court of Appeals to get the Court of Appeals to direct the district court to take or some kind of action, which is basically what a mandamus does. So I'm kind of wondering, Ship, if your answer isn't the right one, which is that this is not a serious effort at a lawsuit or at litigating this issue in the ordinary way. But then you have to wonder, surely the Department of Justice is not just filing lawsuits for purposes of saying we're trying to stick it to these judges.
Well, this lawsuit one slows it down because you've got
Yeah,
built-in delays
right.
for
They got to wait for the
filing
judge to be
answers and filing motions to
identified.
dismiss.
Right. They don't even have a
Right.
judge yet.
Yeah, yeah, and so it has put the slows, so to
Yeah.
speak, to
Yeah.
the issue. Maybe the whole purpose is to get these Maryland judges recused from all their cases.
Well, I don't see that would be a basis for recusing them off of all the habeases. And they're not even asking for that. They're asking for the standing order to be set aside. Now,
How many habeases have been filed since since they filed this lawsuit?
yeah,
I bet you a recusal motion is coming
yeah,
with the first habeas that's filed.
yeah. Well, they had, I mean, okay, so looking at, King, you raised a good question as between the three of us earlier today, looking at the lawyers that are assigned to this case. The department has staffed this case pretty fulsomely, don't you think? Ship, you want to speak to that? I mean,
I
these are not rookies.
Well, I mean, I'm not sure. I don't think I need to look at the lawyers, the trial lawyers actually assigned to it. I mean, it's got the same collection of names from the appellate section and the immigration litigation section of the appellate division immigration litigation section that's on all of these immigration cases, starting with Brett Shoemate
Yeah.
and Drew Ensign. Um, Brett Shoemate, I think Brett Shoemate has been confirmed as the Assistant Attorney General for civil.
Uh, has he been confirmed? His on this pleading, he's
I,
called the Assistant Attorney General Civil Division. So,
Yeah, so he was one of the first 3 or 4 assistants that was confirmed.
mhm,
I think
right,
he's a career. I think he's a career lawyer. He's an appointee, but he was an appointee. He was a career lawyer.
right,
He had a significant position in the first Trump term and didn't leave during the Biden term.
right. So this is not some lawyer in the civil section of the U.S. Attorney's Office in Baltimore or Greenbelt didn't dream this up, right?
Correct.
This is
Correct. This is
DOJ management deciding this is the
right.
way to go on this case.
And Shoemate is the one that argued. He appeared and argued in Breyer's court in the California National Guard. So
Hmm.
he is, even though he's the Assistant Attorney General, he has got a lot of courtroom experience, and he is marching into court to argue these cases.
Right. So King is right. This is not the fastest way to resolve this problem. Like if you were the government and you don't want these automatic TROs and you want that stopped immediately, this is not the way to do that.
Unless what you're really angling for is just that phone call. You want to make this a public spectacle and
Right.
have
You're embarrassing these judges because
and
like what the comments we're making tonight, this is absurd what they're
right.
doing. So
And you have a bench in the District of Maryland. Well, I was surprised by how many judges there are. I don't think Maryland's that big. You know, the Eastern District of California with 6 million people has 6 full-time judges.
yeah. Well, some of these judges are
Are they
senior.
senior? Okay,
Yeah. Like
I didn't look that
yes.
closely.
The judge that I clerked for, Judge Hollander's on here. She's taking senior status. So yeah.
So yeah, I think every one of them is a Biden or Obama appointee. I don't think there's a GOP appointee among the active judges. Um, and the DOJ recognizes that these liberal activists, public interest groups are running into Maryland because they know they're going to get a sympathetic ear from the judge, and the judges have fired off preliminary injunction after preliminary injunction in a couple of dozen cases. So it's like, okay, two can play at this game.
I do think that the judges, I don't have any inside information on this. I have not spoken to my judge about this, nor will I. But I think observing the public record of like the case that Judge Zena's handled, um, I think the judges probably think these cases are very disruptive to them and their calendars if they're filed for injunctive relief in the ordinary way.
Oh, oh,
So,
oh, consider, we'll get to this in a minute. Consider the amount of time this Judge Brian Murphy in Massachusetts has taken
right.
up
Yeah.
dealing with these 6 individuals sitting
Right.
in Djibouti.
Right. Right.
Hundreds of hours of time.
So I can see from that point of view why they would rather that this be handled in an easier way for them. But that's too bad, right? The government, so people will probably appreciate this. They have one of their paragraphs basically says the convenience of the court is not a basis for doing this. Inconvenience to the court is not a basis to enter an injunction. And filings outside normal business hours, scheduling difficulties, and the possibility of hurried and frustrated hearings are not irreparable harms.
And
That's
I think, I
that's
could be
paragraph
wrong.
83.
Yeah,
What?
I could be wrong, but that might be in the standing order as the justification for
The
issuing the order.
justification. Right. Yeah. So,
That that not only is in the order, it just jumps out at you that that's why they put it there.
right.
This is not really to protect the detainees. It's there to avoid inconveniencing the judges who may not want to, come off their golf game in the middle of the golf game to handle a TRO presented to them by an applicant for a TRO in a habeas filing. So that just shouts at you. That's what they were trying to work
Right.
around. And they figured 2 days isn't going to hurt anybody. Nobody's going to complain. So let's do it.
And you know what? In my 35 years in federal court, you know what a lot of that reflects? It's not so much the judges. A lot of them are workaholics. I mean, they have
Yeah.
long hours
Yeah.
regardless.
They are. Yeah.
It's the staff that bitches.
Right.
And this is the judges reflecting the unhappiness of the staff. And we only get paid to work 9 to 5. Why are we doing this crap on Saturdays?
Right.
Exactly. So you want to talk about whether this lawsuit stands?
Well, I wanted to talk first about how unusual it is for the federal government to be filing a lawsuit. It's obviously, maybe we haven't made this point clear, but it's extremely unusual for the federal government to sue the entire bench of a district. I don't know if that's ever been done before.
I don't think it's ever been
Right.
done. I mean, first thing it runs up against is a civil suit. It runs right up against judicial
Right.
immunity.
Right. Exactly. So you got this problem.
You
But then,
you got judicial immunity, separation of powers,
right.
other
I
remedies
mean, all
that are
right,
built into the
all
law, like
kinds.
appeal.
Who's going to
Yeah,
defend them? Like, who's supposed to answer this? Who's going to file an answer to this? The chief?
I want to see the financial affidavits asking for appointment of the federal
My
defenders.
God. Okay, so, but I also wanted to talk briefly because I don't think people will realize this, how unusual it is that the federal government has filed this lawsuit with three equity counts. Right? So there's no statutory claim here, right? In terms of what's the cause of action. They're saying, oh, well, it violates the federal rules of civil procedure and it violates the jurisdiction and other statutory bases as the grounds, the factual grounds, right? But the causes of action themselves, like there's no breach of contract, right? There's no what it's not a tort, right? It's this is not a normal cause of action.
APA doesn't apply.
What?
The APA
The
doesn't.
yeah, the Administrative Procedure Act doesn't apply. So they're not the government is not claiming any kind of normal cause of action. All three of these counts are for equitable relief. And equity allows a court to impose injunctions and order other kinds of equitable relief. But when I read this, I thought, wow, have I ever seen the government file a case where they're not relying on any title in the US code for purposes of the counts themselves. So,
I, another way to put that is that I think it's a serious issue as to whether this is a legitimate case or controversy in the
right.
first place.
Yes, and that's one of your procedural issues. I want to get to that. But in order to try to head off this problem, that is this a proper lawsuit at all? Like, what kind of causes of action are these? It's not like it says, count one is tortious interference with our, rights. Count two is, Administrative Procedure Act count. Count three is lies under the, I don't know, power of the district court in Title Five or whatever. None of that, none of that appears. So, but to head off this argument that what kind of lawsuit is this even? They have a section in here that talks about the government's rights of equity. So, um, where did it go? I had this all teed up. Now I can't find it. Hold on one second.
Are any of the causes of action based in Title 18? Because if they're
Nope.
not, I probably should just sit this one out.
Nope, they're not. This is the crazy thing. It's not at all based in the code. I'm going to have to use the find section. Hold on a second here. Okay, here it is. Count one, violation of requirements for injunctions. Okay, that's not a cause of action. That's the title of it, right? That's the nature of what you're saying the problem is. But it's like when you have breach of contract, you say, count one, breach of contract. Then you explain the contract and you explain the parties and you explain what the breach is, because those are elements of the cause of action. Here, it says violation of requirements for injunctions. So, in order to explain this, what they've done is they say, courts have long recognized that even absent an express statutory cause of action, the United States may sue in equity to vindicate its sovereign interests and enjoin interference with its activities. CEG Arizona v. US, actually there's a typo there, from 2012, In re Debs from 1895, and US v. California from the Ninth Circuit 2019.
My question would be, in defending its sovereign interests, isn't it suing another part of the same sovereign?
I know. See, this is what grabbed my attention, which is this even a lawsuit? Right? What kind of causes of actions are these? Can the
It
government sue the court in the court?
they the relief go to the relief they saw. They
Yeah,
seek one is they seek a declaratory judgment
right,
that this order standing order or orders are illegal, and two, they ask for preliminary and permanent injunctive relief
right.
to
But
prevent
nowhere
it.
in here do they invoke the Declaratory Judgment Act, do they?
Uh, well, they have to if they ask for a declaratory judgment,
Yeah,
which they
but
do.
that if I were them, I would have put that in the title of one of my
Mhm.
counts.
We're going to have declaratory judgment from a judge against a judge.
Right. So this really reads to me more like that's what this is. This is a Declaratory Judgment Act case, and their three counts are not actually counts, they're the arguments for why the standing order is unlawful. And they're asking for a declaration under the Declaratory Judgments Act that the standing order is unlawful. You follow what I'm saying?
Yeah, yes, which brings me back to: are they in the right court? Don't they have to raise that since the order is in effect, has been applied already in number of cases? The only place they should be allowed to get relief would be the Court of Appeals, or go to the district court that entered the order and ask that it rescind it.
Yeah,
And I don't know
yeah, I think
if you get there by getting the order, the judges who have entered the order and are applying it in various
yeah,
cases.
I think the
Uh,
point King's
whether you
making is a good one, which is that, and I mean, I understood this earlier, but the point is that the ruling of one district judge is not binding on another district judge. So because one district judge tells these district judges that your standing order is a
Is for
violation of
shit.
something, is
Then
like, okay, that's your opinion, thanks, go back to where you came
thank
from.
you. Right,
yeah,
It
exactly.
has to come
Right.
from it has to come from a superior court to an inferior court.
or you get the first judge to change his
Yeah,
mind and rescind it. Go to the chief judge in this court and say this order is unlawful. Change your mind. Uh, but the quickest way to resolve it is go to the Court of Appeals. You don't go. You don't create a fake case or controversy when all you're doing is objecting to an order entered by a court in some cases that the government is handling. There are procedural ways to deal with that, and this is not one.
Okay, so they do invoke the Declaratory Judgment Act. They don't name it, but in their jurisdiction and venue section, they say the court has authority to provide the relief from the orders requested here under sections 1651, 2201, and 2202. 2201 is the Declaratory Judgment Act.
Yeah, but it's well established that that doesn't confer confer jurisdiction.
Exactly. This is what Steve is saying is, but the Declaratory Judgment Act doesn't confer jurisdiction. You can invoke it in a case, in a proper case where you have a controversy, where the court has jurisdiction over that case, and then you invoke the Declaratory Judgment Act to get a ruling on what the law is in that case without rendering a judgment on the case, but simply to say what the law is. So this is not now they're not claiming it's for jurisdiction, they're claiming authority to provide the relief.
Right, which is
That's the right way to
correct.
plead it.
But
yeah.
what I'm wondering about is if you go back to Youngstown, when Truman seized the steel mills and it gave rise to the Youngstown case, and there's been a few other cases similar to that, I'm thinking that the courts have said there's an inherent cause of action under the Constitution if you're exceeding your authority under the Constitution. And I'm wondering if ultimately that's not the nature of
What this is.
what
Right.
this is.
I don't know if that's ever been used against the judiciary, though.
I don't think so, but it's used against the executive. I mean, the president, typically when you sue the government, you sue an agency. And if you're suing an agency, you can use the Administrative Procedure Act. The Administrative Procedure Act is the workhorse day in and day out. But the president himself, the office of the president, is not an agency, so you can't use the APA against him. And the judiciary obviously is not an administrative agency. So that creates this sort of vacuum. And not only is it not in Title 18, as Bill was lamenting a few minutes ago, which is the criminal code, but it's not in Title 28 either, which is where most of the civil stuff is.
Right. So, okay, they say they have jurisdiction just under the normal statutes, 28 USC 1331, 1345, 1361. They're just saying, the federal court has jurisdiction over actions arising under federal law and so forth. But then what federal law is that in this particular case?
I would go back to case and controversy.
Yeah.
Jurisdiction, I think, is a blind alley. This is not a true case or
Yeah, but
controversy.
the assertion of the jurisdiction and the authority for relief are bricks on that wall that you're building there, King. I'm agreeing with you. And the way to analyze to conclude that this is not an actual case and controversy, at least not. It's obviously a controversy in the general sense, but in order to be in federal court with a lawsuit, there has to be an actual case there. And one way to
and,
analyze that is what we're doing is to say, well, what did they invoke for jurisdiction? Does that make sense? What did they invoke for their authority for the court to act? Does that make sense? Right?
and here, what they're doing is they're making an end run around the cases and controversies that are already before this
Right.
court, and the government is a party in these habeas
Right.
cases, and the law is clear. If you don't like what the judge has done, there are things you can do as the government to get it overturned or try to get it overturned. And the first place you think of is the Court of Appeals. That's what the judiciary is. Is a forum for controversies to be decided. You don't sue the forum.
Right.
Yeah, you don't sue
Right.
the forum. You
No, because they're not a part of the case. Right?
correct.
Yeah, right. Yeah, it's crazy. So just so people know, I read out what they say are the authorities that allow the court to provide the relief. Okay, so that's different from jurisdiction because you can have jurisdiction in a case where the court doesn't have the power to give relief, and so you have to have both. So the grounds that they're saying that the court has authority to provide relief are these are all in Title 28. Title 28 is the one that governs the operation of the courts. And so they're relying on 1651, which is basically like the All Writs Act, okay? 2201, which is the Declaratory Judgment Act, and 2202, which is a statute that says the courts can provide further relief that is appropriate in the case. Lawyers always throw that in. Okay, but then for jurisdiction, they're saying 1331, which is the federal question jurisdiction. So they're saying, this is the federal, not a state controversy, right? And then they rely on 1345, which is cases where the United States is a plaintiff. So they've decided themselves that they're the plaintiff, so that that provides one ground of jurisdiction. And then the other one is, do you happen to know off your head, top of your head, what 1361 is? Because I don't. All right, let me pull it up here and see what it is. So what are you thinking of this? Are you also questioning whether this is like an actual case?
I haven't thought it was since first I read it. I thought it was a stunt.
It's a stunt, right?
And I think it's, it's
Oh,
DOJ's sharp practice way of fighting back against what they see as lawless district court judges employing every sleight of hand to impose, you know, preliminary injunctions without a lawful basis for doing so, but using as their advantage the fact that until you get them reversed, their injunctions are in place. I think it's in some ways it's fighting fire with fire.
and we don't like it, so we're going to sue you.
Yeah, well, no, we are going to embarrass you in a way that's available to us as a litigant. We're going to make you the defendant, and we're going to call out something you're doing that is unlawful. I mean, I don't know why they didn't just make an ultra vires claim and say you can't issue. It's unlawful to grant temporary injunctive relief upon no showing. There's no case authority, no statutory authority that makes any part of this lawful.
Right.
So the standing order is not just invalid, it's contrary to law.
Right, which is Administrative Procedure Act type standard, but that doesn't apply to them. So it's just fascinating, kind of interlocking issues here. So 1361 turns out to be that a section that gives the district court original jurisdiction of any action which is in the nature of a mandamus to compel an officer or employee of the United States or any agency thereof to perform a duty owed to the plaintiff. That's just wildly inapplicable to the court.
Is a judge an officer of the United
Almost
States?
certainly not, right? Steve's asking, is a judge an officer or employee of the United States? I think the answer on statutory interpretation is going to be no. They're definitely not an employee of an agency. So, and what duty is owed to the government that in this situation?
Follow the law.
Yeah, the courts have said that doesn't cut it on these. So, right. Well, okay. So, wow. So the problem is this is not an actual case as the lawyers would interpret it to be. Do you think there is a case in controversy, King, that maybe it's just not pled properly? Well, King has gotten kicked out somehow. I'm gonna send him another co-host. Ship, you want to answer
I
that?
actually liked King's idea, which was take every mandamus case that's still pending,
Habeas, you mean?
habeas case that's still pending, regardless of whether the status of the 48-hour automatic stay, if it's
Right,
expired or whatever, just don't ignore its current status.
right,
Take every case, file interlocutory notice of appeal in every case at the same time.
right.
Make it the Fourth Circuit's problem. And then in every new case that gets filed, file the same thing day one. The order's in place.
Right.
And just keep doing it until the Fourth Circuit responds.
Well, they've obviously decided not to do that. I would be really dismayed if the reason they've decided to do it this way instead is because they're simply trying to embarrass the district court judges.
The, the,
Some of whom may not even have agreed to this, of course, right? Because
and you got to be careful when you file weird stuff in court because it often backfires.
yeah,
And I'd be afraid if I were one of these lawyers, one of these government lawyers, I would want to think twice before I did this for fear that it could well backfire.
well, there's probably a reason that none of the four of us have ever even heard of this before, right? No one knows of this being done in the past. I'm not saying it hasn't been. I haven't, researched the hell out of that, but I would be shocked if it has been. That should tell you something. The DOJ is not supposed to be going around doing, make it up as
If
you go
this
along.
if this has ever happened before, it would be taught in law school.
I think that's right.
I mean, what a great tool if if you're
Yeah,
not the
for the
court.
government.
Yeah,
Yeah, for
I
sure.
can think of dozens of ways to use this to uh,
For the
effectively
executive branch
intimidate the court.
to
Yeah,
beat up the judiciary in a way that's
yes,
not appropriate. Hmm.
yeah. Uh,
Judges are officers of the United States.
Okay. Steve's done some research just right now and said that what are you looking at, a statute or a case?
Under the Constitution.
Okay. He's saying that there's some law that says under the Constitution, judicial officers are officers of the United States. So let me look at that language again. Um, okay. So the statute, this is one of their jurisdiction statutes, to compel an officer to perform a duty owed to the plaintiff. So they're going to have to say, well, these judges have a duty to not apply that standing order to us as the government. But that doesn't usually work. The you have a duty to follow the law argument very seldom is successful. Okay, so what do we expect to happen with this?
your
I,
guess is as good as mine.
John
We're in
Roberts is
uncharted territory here, right? John
going to
Roberts picks up
file
the
a motion to
phone.
dismiss.
Yeah.
He's going to file a motion to dismiss.
He files a notice of request to appear pro hoc vice
Yeah.
in the district court of Maryland.
Once the clerk's office decided what judge shall hear the case.
Oh my God. And see, how does that make any sense? You sued the clerk's office. Now you're asking the clerk's office to go find you a judge to hear your case. How is the clerk not recused?
This exercise, in great measure, is part of the caution that I give in trying to figure out why criminals sometimes act as they do.
Right.
Do not search for rationality in
Where
the
there
midst
isn't
of
any.
irrational conduct.
Right. Yeah.
This is going nowhere. There's no conceivable path for this case to move forward on the merits. There's no venue. There's no certainty of a remedy.
Right.
If it's not voluntarily dismissed by the government, it's going to be ordered to be dismissed by whoever is put in a position, probably by the Fourth Circuit. But
Well,
I
yeah,
think
and then you run into King's point of, okay, and then are these lawyers going to get sanctioned for filing something that,
you
boy,
know
these
what
guys with these big jobs should know better?
they better hope that they're going to find themselves right where Jeff Clark found himself for writing a memo, which
Right,
is a state bar looking to disbar them.
right. Well, okay, so let's talk for a minute about the other side of the V. We've been talking about the DOJ. What are these judges going to do to defend themselves? I mean, they're sued in their official capacities, right? They're not personally sued, like their assets are not on the line. Most of these judges, half of them probably weren't in on the conversations about should we do this standing order or not, right? But the government has sued them
Oh,
all because
maybe the senior judges weren't. But I guarantee you,
Yeah.
every active judge was given a memo saying, "What do you think about doing this?" And I'm confident none of them objected, especially based on your description of how the District of Maryland just employs, standing orders willy nilly.
Right. But that leads to the situation where people are like, well, the chief's going to do it anyway, so I'm just not going to say anything. Right. So I don't know. We'll see. But I mean, really, they're going to all have to hire lawyers, right? Or, I mean, or get this, is the government, because usually who represents judges when they get sued in court? Chip?
A DOJ would typically,
Yeah,
scope them
DOJ.
if they're acting within the scope, of course, the scope of their employment. DOJ
Right.
would
Right.
either
The
defend
government
them
would.
or hire lawyers to defend them.
Right.
They got one of the big law firms as part of the pro bono that they owe to Trump to do it.
Yeah, Steve says maybe they should get one of the law firms who offered all that free pro bono work to the president to defend
I
these judges.
maybe it's that one that has the acronym H&H.
Right. Yeah. So, we'll see, but I just think it's crazy that they issued summonses. If you look at the docket, they requested the clerk to issue summonses to all of these judges. The service on that's going to be interesting. I'm assuming they're all going to voluntarily accept service, right? Can you imagine being the marshal there? You got to go serve every judge in the courthouse and the clerk. Good grief, what a nightmare. So, okay. Um, we'll see what happens with this, both, in the court of public opinion. The people, just normal, ordinary people on the right, were cheering this today precisely for the reasons you've identified, Ship, where people are kind of sick of some of the district courts interfering too much with, especially the immigration things, because it's seen as, interfering with the proper functioning of the executive branch for a change. So, all right. Any last comments on this before we turn to Massachusetts?
That's all I got. It's just a ball of twine, and we're going to have to just roll it down the hill and
Right.
see what's at the other end.
See what comes out, right? Because it's a wow. This case is a wow. So, okay. All right. Now in Massachusetts, Ship, you wrote a really great Substack article on this. Is that one free too, the one you did today?
No, those ones that I put a lot of effort in. I got to
Yeah,
defend my
there's some that
time
are and some that
investment there.
aren't.
So,
Yeah.
they're all free after 10 days. But that
Oh,
one
okay.
that one's quite. Yeah, I mean after 10 days, basically anything of mine can be read.
Okay,
So
great. All right. So the issue here is that this is another one of these immigration cases. It's the one related to the Supreme Court decision on June 23rd, which was not that long ago, in which the Supremes issued an order entering a stay of preliminary injunction entered by this judge in Massachusetts who had ordered the government basically not to remove some folks who filed for habeas. Okay. And having done that, the court did not say on what grounds they were entering the stay. The government had sought the stay of the judge's preliminary injunction. They argued a bunch of different things. The Supreme Court did not issue an opinion. It's just a ruling on the motion for stay. The majority of the judges granted it. Justice Sotomayor wrote a long dissent, she was joined by both Kagan and Katanji.
yes,
Is that
yes.
right? And yeah, so, and she, gave all of her reasons for why no, we should not have entered a stay. But there's no majority opinion because it's not an actual opinion. It's a ruling on a motion, and the justices are entitled to, and they do with some frequency now, say why they would have ruled the other way. Okay, so normally, of course, when the Supreme Court speaks, the lower courts are supposed to obey. That's the way it goes. But the judge in this case is continuing to impose certain requirements on the government, which are identical, I think, to what the requirements were in the preliminary injunction. But this case has an extremely complicated procedural status and background to it. You really have to dig into the docket of this case to understand it. So, and I know you looked at the docket, Ship, because I can tell from your article. But did you pick up the flavor that I did from this judge that he's really mad? Like he's really mad.
Yes, because while the case was pending and after he had entered a TRO, the government used some creative maneuvering to evade his TRO. He initially certified a class that would be so just so everybody understands the facts. The facts here are somewhat limited. This only applies to illegal aliens who are being removed to third countries, meaning a country other than the country they were initially designated for removal to. So normally, in most instances, an illegal alien being removed is going to be removed to their home country. Some instances, it's to a different country, but in either case, the country of removal is listed on the removal order. But maybe that country won't accept the person. And under that circumstance, the statute provides for, I think, 5 alternatives at the government's election. One of those 5 alternatives, maybe the last of the 5 alternatives, is basically to any country that will accept
It's
the
more than
deportation.
5. It's like 9 or 10 because it's like where the person was born, where they came here from
No, no,
originally, where they lived before.
right. But the first 2 are set up as like the 2 alternatives. And then in the event that neither of the first 2 alternatives are available, there's
Yeah,
5 options
I
at the
see. Okay.
government's. The deportee gets to weigh in on the first 2. Does he want to go to his home country? Does he want to go to the country where he last resided? Does he want to go to the country where he entered from? If none of those 3, but so he has an input there. I want to go back home. Okay, we'll send you back home. Then home won't take him. The individuals that are subject to this dispute are individuals where their countries would not take them. And the 8 specific named individuals were all refused repatriation to their home countries because they have violent criminal convictions in the United States.
For
And
which
so
they've
they're
served time.
undesirable.
So they were
Right.
locked up for that, you guys. So, yeah.
And now they've been released, and the U.S., obviously, they're subject to removal, but their home countries won't take them back. So, what is the remedy for the United States for a violent criminal alien whose home country won't take him back? Well, what the the Biden administration generally just threw up their hands. Some of these individuals have been released and are back in the community. They served their criminal sentence, and because they couldn't be removed to the designated removal country, the Biden administration just let him go until
Oh, well.
that problem could
Right.
be could be corrected. Others were kept in custody. They've been in custody for years while trying to figure out where to send them. But I think the long and short of it is the Biden administration and the Obama administration wasn't working too hard to solve these problems. The
Yeah.
Trump administration decided, you know what? We're just going to bribe countries to take these undesirable. We're going to go to poor
Right.
countries and offer them money to take these people. And so the State Department has been out negotiating the removal of Trinidad members to El Salvador was pursuant to such an agreement. They had apparently an agreement with Libya that fell apart, and then there was an agreement with
Much like Libya.
yeah, and then there was an agreement with South Sudan. So a group of individuals. So this while this complaint is pending, it was filed March 23rd, I think, and the judge had entered a TRO. The issue was he designated a class and made his TRO applicable to everyone in the country, any individual subject to deportation to a third country other than their country of removal, that they had to be given an opportunity to protest under the Convention Against Torture the new third party or third country of removal. So, not the original one that wouldn't take them, but the new one that has now been negotiated. The judge said they have to have an opportunity to file for relief from the removal order on the basis of the Convention Against Torture, that there is a more likely than not chance that they will be tortured by the government of that country that has agreed to take them.
Now, so people understand, 2 points. One, in this case, you're correct. The case was filed on March 23rd. The judge didn't issue the TRO until 5 days later, March 28th. Meanwhile, the parties filed motions and some other, they filed pleadings and some other things. So, unlike this 48-hour automatic business in Maryland, in Massachusetts, it took 5 days for the detainees to get the TRO put in place. The other point is that on this torture thing, I want people to understand, we as a country have signed up to an international treaty to try to eradicate torture, right? And as a part of that treaty, we agreed to implement that treaty by putting these kinds of provisions into our federal law. So the federal law allows for people to object to being sent back to XYZ country on the grounds that they would be tortured, not because the country is got a lot of, violence or whatever, but that they themselves would be personally have a reason to think that the government of that country would torture them. Which you could see how that would be in cases where maybe they fought as a guerrilla fighter for the faction that lost, right? And now the other people are in charge of the country. Okay. So we implement those treaty provisions by what Ship's talking about. We have a procedure already for the folks to say, you can't send me back to XYZ country because I'm going to be tortured if I go there. These people have already had this review in their case, but then the country that we were going to send them to didn't take them. And so now we want to send them someplace else. So the question is, are they entitled to another review under the statutory provisions which flow off of this treaty that we've signed onto? To
I
say,
think, for example,
I
just
could
to
be
give
tortured
one
in
example,
new country.
right? To give one example, just so there's a concrete example, and one of the individuals that is implicated here um, is from Vietnam, and I believe his country of removal had been designated as Myanmar, and Myanmar refused to accept him. So I don't know why Vietnam is not the alternative, but the third country selected was initially Libya, but then the Libya deal fell apart, and later it became Sudan, South Sudan. So this individual who's Vietnamese has a serious felony conviction and prison sentence that he served in the United States. The country of removal was Myanmar, and then Myanmar refused to take him. So he's been sitting in custody, waiting to go somewhere, and then they tell him, "Oh, you're going to South Sudan," and that's the first time he knew he was going to South Sudan. And his lawyer said, "But he doesn't want to go to South Sudan, and you haven't
Right.
given us a chance to make." Now, the interesting thing about the Convention Against Torture claim, first of all, the burden of proving that you are more likely than not to be tortured is on the
You.
individual.
Yeah.
The government
Yes.
doesn't
Yeah.
have to prove you're not going to be tortured. You have to prove that you are going to be tortured. So how somebody from Vietnam could establish that he's likely to be tortured in South Sudan, how he's supposed to prove
Right.
that is, it's quite a mystery.
Right.
The
So this
second,
is a creative lawyering by these immigration
right,
lawyers. But
the
at
se-
the same time, I want people to know the lawyers and the judges, they're not making up this torture issue like, oh my goodness, that's like some claim that this guy's making up out of nowhere. No, it is a regular part of the process that we implement because we've signed up to this treaty. Of course we want to not people to be tortured, right? We're on board with that in a theoretical
now
sense.
the the other thing that's important to know about the Convention Against Torture is that while there are exceptions to certain other removal provisions, exceptions in the sense that if you committed a violent felony, you're ineligible for asylum. If you are a member of a terrorist organization, you're ineligible for asylum. There's no such exemptions to Convention Against Torture applications. If you're a member of ISIS, you can still make a CAT claim if you're in the United States getting ready to get sent to South Sudan. You get to file an application to halt your removal under CAT. That's part of the treaty that Bill Clinton signed and had ratified by the Senate in the 1990s that signed us up for this. So these limitations on who can be prevented from making a cat claim are written into U.S. statute. They can't, unless Congress changed it. If Congress was to change it, we'd be in violation of the treaty that the Senate
Right. Exactly.
confirmed. So we'd have to withdraw from the treaty. So there's lots of complications, but the actual ability to win a cat claim is practically zero.
Right. You'd have to be in the situation probably that I posited, that you
Yeah,
fought for
exactly.
faction A and faction B won, and they
Yeah.
now run the country. Yeah.
And they want to send you back to that place where, you
Right.
are a disfavored person, so what all the judge has really ordered, I mean, it's extreme. Okay, the other thing I want to mention about all of these individuals, they've served their criminal sentences, they've got no appellate rights left, they've got no due process rights connected to their criminal cases, they've been through the immigration system, they've got a final order of removal, they've got no due process rights left with regard to the immigration system, except that the judge in Massachusetts has said, when you introduce a third country not previously in the mix, they have to have an opportunity to file a cat claim as to the third country. No other claims, just the cat claim. And so he put in place an injunction to prevent them from being removed from the United States
until
until
that gets
given a
resolved.
chance to file their
Right.
cat claim. Take it for a minute from there if you know what to say next.
Okay. Yeah. All right. So that's basically what he ordered, and he ordered that at the end of March, and the government promptly appealed that. The TRO. And then they have later withdrawn the appeal on the TRO because the TRO got replaced by a preliminary injunction. So the judge issues the TRO. He set a schedule for hearing and briefing on the preliminary injunction. He had that hearing on April 10th. The government also asked for a stay on the TRO. He denied that. And so they marched on ahead to the preliminary injunction. They had that hearing. The judge issued the preliminary injunction on April 18th, about a week and a day after having the hearing. The government had already filed, even before he ruled, they had filed saying they wanted a stay. They filed for a provisional stay because they knew, obviously, after the hearing that he was going to issue the preliminary injunction. So they got that on file. The judge denied their request for a stay, and then so the government promptly filed their notice of appeal on April 22nd. So that case went to the First Circuit also. Then, about a week later, the judge had a status conference and he ordered a bunch of other stuff. One of the things he ordered was for the government to identify those who had final removal orders who were then subsequently removed from the country on March 31st and April 13th. So remember I said he issued the TRO on March 28th. So while the TRO and or the preliminary injunction were pending, the government allegedly removed some of these dudes anyway.
Okay,
He
let me jump in here with the important fact. This is what I was thinking about, and I got sidetracked. One of the things that happened was some of these ultra bad individuals were actually being detained at Gitmo. Right. And so at Gitmo, they're in the custody of the Department of Defense. That's a Department of Defense facility, not a DHS facility.
Right.
And the Department of Defense officials gave them 12 hours notice that they were going to Libya or South Sudan or wherever, and then put them on a plane and shipped them. The plaintiff's lawyers, filed a motion for breach of the protective order.
Yeah, they freaked the fuck out. That's the technical term for it.
Right. And the government came back and said, well, you only sued DHS. Your preliminary injunction only referenced DHS, and this was not DHS. This was the Department of Defense.
Yeah. Our buddy Pete, he said, you know what? I got some planes, and they happen to be going the same place where you guys want to send these dudes. So, let me help you out.
So that is the first thing I think that hacked the judge off. That is
Oh
the
yeah.
first time where he was
Yeah.
angry because
Yeah.
this is a brand new judge. That's something I didn't mention. This judge was
Yeah.
confirmed in the middle of December 2024 after the election, 4 weeks prior to, or 3 weeks, no, 6 weeks prior to the inauguration. And he's not necessarily somebody that I would identify as not being qualified by his background. Um, relatively distinguished course of service. He was an assistant federal defender for several years and did other things up in Massachusetts and Boston. He wasn't somebody that would have just been rejected out of hand, but he hasn't been a judge very long. And
Yeah.
he wrote that first preliminary injunction and only dealt with the parties named as defendants in terms of how he
Well, I mean,
worded the
in
injunction.
his defense, who would have thought that the DOD would swoop in there and send them
Correct.
as opposed to
Right.
DHS?
So then
Right.
he modified, he amended or modified to make it that it would be DHS or any agency acting on behalf of DHS. Because the government, I think, had to concede in the hearing that became another contentious point that DOD doesn't have deportation authority.
Right.
That enforcement or
Which is
carrying out.
probably why the judge didn't think he needed to list them in his order.
Right. So any order to carry out an order of removal can only be put into effect by DHS by
Right.
statute. So the DOD physically handled it, but they handled it at the designation of DHS. So and so he found that it was a violation of his preliminary injunction. Now, the
But we're going
guys
to
that
get to that. Okay, so he issued that order saying you got to tell me, who did you send, etc. on April 28th. So at that point, the government's already filed its notice of appeal. Okay. Then he made them file memos on could he amend his preliminary injunction. And both parties told him that he could amend his preliminary injunction, even though it had been appealed, because there is some law that says within a narrow range, the district court can still modify, amend their uh, preliminary injunction if it's to keep the status quo as specified in the preliminary injunction, right? So you're not really changing the overall substantive effect, but you might need to tweak it because, some shit has changed in the meantime. Okay, the government had to concede that yes, the law did allow that kind of narrow exception. All right, so he went on ahead and modified it, as Chip has told us. And then that was on April 29th. And then a few weeks went by. And then on May 18th and May 20th, the immigration lawyers filed emergency motions for TROs and preliminary injunctions again. And the judge set a hearing for that on 3 days later on May 21st. He then actually held the hearing the day before on the 20th. Now, what's fascinating here is on the docket, the hearing date never changed. But the docket says that an emergency hearing was held on the 20th instead of the 21st. And the motions filed by the lawyers were for another TRO and a preliminary injunction. But the docket says that the hearing was about those motions and also whether the government was in violation of the earlier preliminary injunction. So at some point, this judge changed what was on the table for the hearing, and he apparently called the parties to have a hearing. It looks like telephonic or maybe Zoom or whatever before the hearing was set the day before. He just initiated that. It's what it looks like to me. Ship, what do you think of that?
Okay, the complication there is there's actually two sets of subjects. There was
Yeah,
the one that's referred to OGG, who had
yeah,
already been sent to Mexico. And so
right,
he's kind of running parallel proceedings. One, because the plaintiff's lawyers had come back and filed a separate motion
Yeah.
for a new preliminary injunction that was only as to OGG, because his facts
Right.
were different than the ones on
Right.
their way to Djibouti.
Right.
And so I think the hearing that was set for the 21st was actually for OGG. And then he has an emergency telephone conference on the 20th, gets some information, gives both sides some instructions, and then they resume that the following day on the 21st at the same time that was already set for the OGG hearing, since everybody
Right.
was going to be there.
Right. Right. Because you're right. There are two motions by separate motions by the immigration lawyers. So they're representing different clients, both asking for emergency TROs and preliminary injunction. But what got my attention was neither of them asked to have the government found to have violated the earlier preliminary injunction. The judge added that himself, it looks to me like. And then when the government opposed all of these new emergency injunctions, they filed their opposition, because he ordered them to file it quickly. They filed on May 20th, and there are literally no facts in that motion. They don't say what happened with any of these folks. They go right from their introduction straight into their legal argument. They didn't want to put in any facts, it doesn't look to me like, that would explain what was going on with this, because his preliminary injunction was pending when all this stuff happened with the DOD. So rather than put facts in that maybe they might have to walk back later, they opted for no facts. But okay, so but the judge is obviously really angry at that point, don't you think? That's why you're getting this.
Right. So what he did is he entered two orders. I think it's on the 21st. One was a finding that the government had violated the preliminary injunction from April 14th.
Right.
And a second was a remedial order telling the
Yeah.
government what it needed to do to remedy its violation.
Right.
And the government filed a motion to stay and a motion for
And for
reconsideration, and he
reconsideration.
denied
Yep.
both of those. And then the
Yep.
government, because the appeal of the First Circuit, the appeal of the preliminary injunction was still pending in the First Circuit. First Circuit
Yeah.
is denied a stay, left the injunction in place, set a briefing schedule. So that's
Right.
still
That case
pending
is
down there.
still pending. Right.
Right.
Still pending tonight.
So,
Yep.
so the only place the government has left to go is to the Supreme Court. So on the
Right.
27th, they file an application for stay of the original April 14th preliminary injunction with the Supreme Court. And the plaintiffs file a response to that, and it sits for a month from April 27th
Right.
until no, from May 27th until June 23rd. Not a peep out of the Supreme Court. Now,
Right. Meanwhile, well, let's say that First Circuit did a good job, right? They handled the request for stay in a relatively short period of time. They denied it, right? The government wanted to stay on the preliminary injunction. The circuit denied that, but they docketed it immediately. They had them brief it. They issued an opinion promptly, so then the government could go properly to the Supreme Court. But the government only took to the Supreme Court the first preliminary injunction.
but it did so after the finding that they had violated the preliminary injunction and after the entry of the remedial order.
Right.
But in their application for stay, they only say that they're seeking a stay of the preliminary injunction dated April 14th or April 18th, April 18th,
Right. And I went
2024,
back and looked at the
2025.
cover sheet of what they filed with the First Circuit. That's what they said also. They said they were appealing the preliminary injunction.
But
They
at that
don't,
point, but at
that
that
hadn't
point, that's all
happened
there
yet.
was. That's
Right,
all there was.
exactly. They didn't go back and amend that, as far as I could see, with the circuit.
Right. So finally, where we started is the Supreme Court issues an order on Wednesday or Tuesday, no, Monday, 2 days ago, granting the stay, but not saying why. And then we
Yeah.
have Justice Sotomayor's 19-page dissent that has one sentence in it, one sentence in her 19-page dissent that represents the views of three justices that says the remedial order telling the government what it needs to do with respect to these 6 individuals in Djibouti in order to be able to lawfully move them to South Sudan. He put in place a bunch of procedures that they must go through that they could never go through, essentially compelling them. What he's been compelling them to do, and what the government has been resisting because they think his order is illegal, is to bring them back to the United States.
Right.
This is kind of with the Kilmore Abrego Garcia thing. It's all sort of the same problem. The government could, as a practical matter, easily do what the court is telling it must do, but it is objecting to doing that on the basis that it believes the court's order in that regard is unlawful.
The court doesn't have the power to tell us
Right.
that. We could do it, but we're not going to.
Right.
Right.
It's an Article 2 versus Article 3 fight. And
Right.
so again, in his remedial order, it basically said, you can send these guys to South Sudan, but you have to jump through hoops A, B, C, and D before you do, or you can bring them back. Well, A, B, C, and D are practical impossibilities on a small military base in Djibouti, where they're currently just being temporarily held before being sent on to South Sudan. So,
which is where it's all going to end up eventually.
So Justice Sotomayor's dissent has one sentence that says, the remedial order entered by the court is not before this court.
Right. She correctly points out the government didn't appeal that. They only appealed the earlier preliminary injunction. She's not wrong.
But the question is, do they have to? I mean, that's the remedial order.
What's
the remedial order? He's saying the judge's argument is, or the judge's argument is now saying, well, the remedial order is addressing the violation of my injunction, and even if my injunction is set aside, I still have the right to address the violation of the injunction. And the government's position, correctly, is not by enforcing the injunction.
Yeah, no, you don't. If you want to hold us in contempt, you can hold a hearing on that, but that's not what you're doing.
As Judge Boasberg has done. But Judge Boasberg didn't say, well, I had an injunction, you violated it, and I'm entitled to, even though it's been set aside, I can still defend my authority to issue it by forcing you to comply with it. That's what the judge in Massachusetts is saying.
Right.
He's saying, you still have to comply with my remedial order.
Because he's going on the technicality that you didn't appeal that, which they didn't, right? They didn't amend their filings with either of the appellate courts to include that. He's not wrong about that. But at the same time, that's super hyper technical because the remedial order says the same thing as the preliminary injunction, which the Supreme Court just said you can't do.
You're wrong. Yeah, they just said you're wrong to have issued that injunction. Right. And there were only two grounds. One, he lacked jurisdiction. So he is saying I can enforce a preliminary injunction through a remedial order that I lack jurisdiction to enter. Or they're saying that the defendants have received all the process they're entitled to under the law. There's no due process violation. In which case he's saying, yeah, but I'm telling you have to give extra process, not just due process.
Right. You got to have my process. Well, the Supremes could have made it clearer why they did this, but they often don't on these kinds of motions. They just do what they do. That their order says that preliminary injunction is stayed. That's what they were asked to do. They say is stayed while the First Circuit resolves the actual issues on appeal, which the First Circuit is doing according to its ordinary schedule. Because the First Circuit doesn't care where those guys are.
But I think the best argument for why the judge is wrong and why Sotomayor is wrong is if Sotomayor was right, she wouldn't have written for 3 people. She would have written for 5+. So, I understand your hyper-technical point that they didn't amend and include it, but 6 justices have said, by not voting with Sotomayor, that they don't think that's an issue.
Well, so if the second order was substantively different, it would make a difference. But
it didn't make a difference to 6 justices.
Exactly. So, But I mean, I'm a little frustrated with, if they didn't think he had jurisdiction, then why didn't they just say so? Because if he doesn't have jurisdiction, that's the end of that case. But that's not what they
Right.
said.
They would, but again, that's kind of the Roberts approach.
Right.
That's not our decision at this point. That's the First Circuit's decision.
Right.
The judge said he has jurisdiction. The government has appealed that issue to the First Circuit. The First Circuit has not yet made a decision. We would be jumping ahead of the First Circuit if we
Right.
were to weigh in ourselves on the shadow docket.
Right.
In fact, it's pending. It's been fully briefed.
Right.
And that's the Roberts approach.
Right.
Is let's stay in our lane. We'll act when it's our turn to act.
Which sometimes
But
is right, but other
yeah,
times now
I
you've put
agree.
this district judge and these litigants and the government in this position of because
But you know what? I don't think any district judge jumps on a sentence out of a dissent and says, "Aha!"
well, but
That to
see,
me is
a
the most.
new judge might, right? Because
That
he's sitting
well,
there thinking, okay,
and
but you
he's
didn't
gonna.
appeal. You didn't appeal my other order. Okay.
Again, though, he's missing the forest for the
Yes, for the
trees.
trees, exactly. Because he might be oh so technically right that that order is still in force, except when you see that what the Supremes did in in staying, because they didn't vacate, they just stayed his preliminary injunction, then it doesn't make any sense that your other order is in force. That
But
makes
again, that
zero sense.
right.
But it's not quite. I saw some commentators on the right saying, well, this judge is just doing what he wants to anyway. He's just flouting what the Supreme Court said. Okay, in a way he is, but in a way he's not, because he thinks there's technically an argument that this is a separate order. It's still in effect. They didn't appeal it. That's the rule. You have to appeal it, right?
Yeah, but
So
again, though, that assumes for that to be a valid calculation, that assumes that Justice Sotomayor kept her view a secret from the other six, and that the other six never knew that she had asserted that the remedial order wasn't before the court. If the other six knew that she was going to take the position that the remedial order was not before the court, and they didn't vote with her, so in their view, the remedial order was part of the injunction itself. Because all he's doing is
well,
enforcing the injunction.
yeah, with his remedial order. I don't know whether you can say that those six knew that or not, right? Because would it have been in the record that was before them when they filed for the stay? I
No.
think the answer is no.
That's going to be it's going to be circulated in a memo between chambers.
Well, assuming the clerks did what I did and read the docket, right, and looked at it, you can see exactly what happened. But yeah. So it's kind of raising a technical point,
They
which
have to
is
vote. There has to be a
true on
vote at
its
some point.
face, but it kind of doesn't really matter.
Yeah.
So now the government has that now, which I think is a stupid move, but they've done it. They have now filed a motion in the Supreme Court asking them to basically clarify to this district judge what their order from earlier this week means.
Right. Quoting his order.
Yes.
Basically saying, is this really what you guys meant?
Right. Yeah.
Did you really stay him? So, but the government makes an interesting point. Did you read the government's supplemental
I
filing today?
just
The
skimmed it.
reply?
The one in the Supreme Court.
The reply, yeah.
Yeah.
They make an interesting point that didn't occur to me at first. They point back to the opposition to the motion for stay, where the plaintiffs argued the only thing standing between these six defendants and South Sudan is the preliminary injunction. Now they're saying, oh, no, the remedial
but
order.
wait, because
but wait, the
right.
remedial order is really what's standing between them and deportation to South
Right,
Sudan, not just the
exactly.
preliminary injunction.
Right, yeah.
So,
right. Well,
in fact,
because what happened was when the Supreme Court ruled on the 23rd of June, they immediately went back to the court the same day and filed another emergency motion
right.
to clarify that, to enforce the later order, to enforce
the remedial
remedial order,
relying on Sotomayor's comment.
Right.
That the remedial order was not before the Supreme Court, therefore it's not implicated, and therefore it's still subject to enforcement.
And he denied that motion, saying, you
He said it
don't
wasn't
need that.
necessary
Yes, you don't need that because obviously my May 21st remedial order is still in full force and effect.
because it wasn't before the court, because that's what the three dissenters said.
Right. So in a way, I understand why Sauer and those guys filed in the Supreme Court rather than with that judge. Because what are you going to file in front of this judge now?
Right.
He's already denied your motion on the remedial order. He's already denied your motion for reconsideration and to stay that order. They would have to appeal, but can they appeal now? Let's see. That order went into effect on May 21st. Today's June 25th. Steve, is that 60 days to appeal the government?
Appeal the order he entered yesterday?
Steve. No, that May 21st order.
Well, yeah, the government always
Does the
has
government
60
have
days to appeal.
60 days on an injunction to appeal? Steve says yes. So the
Yeah.
government could still appeal that order.
But the stay isn't an appeal. The stay is just to set aside the enforcement. The government, the Supreme Court hasn't said the preliminary injunction is wrong.
Right.
You know, by granting the stay, they're tipping their hand because they're
Right.
basically under the winners factors. They're implying that the government is likely to prevail on the merits, but they're not staying that because that question is before the First Circuit.
Right, and they could be likely that they'll win, and then when they have the argument, the court says, "Oh, actually, no, you lose."
Right.
But I'm just saying, the government, if you are talking about what procedural move can we make now in the district, if U.S. District Court for Massachusetts, I'd slap a notice of appeal on them and say, we're appealing this May 21st order. You saying it's in effect, we're saying no, it's not.
I'm sure they can, but if they can get a clarification order from the Supreme Court in 5 days, that ends the issue.
Yeah, but are the Supremes going to issue such an order?
Oh, I think they have to. They went to the trouble of staying it. Why would they leave it in flux when one sentence, we hereby clarify our prior order to make clear that the remedial order of May 21st is included within the scope of our stay.
Right. Yeah, they could easily do that. But to do that, they're going to have to sift through it all. And I bet you they paid zero attention to that remedial order before now.
Right. That may very well be true. But what they'll see is exactly what the government pointed out, that the remedial order is just a Trojan horse for enforcing the preliminary injunction.
Right. You can't do X, and then you also can't do X again. So,
it's not word for word a repeat. He modifies what the remedial order is slightly from what the preliminary injunction, but it is basically the same impossibility.
Right. Right. Which is what would convey, I think, to a more experienced judge, this would not be happening. Right. Because a more experienced judge would be like, it's all part and parcel of the same. So
yeah, he's letting himself be run around by these immigration lawyers.
Yes, he is. And to the extent that, do you think that this is even valid, that he found the government in violation? I mean, he didn't give them any notice, not enough. I was talking about giving people notice. He didn't give them notice of that. Did they have an evidentiary hearing on that? What the hell?
I did not read that part of the docket that closely, so I don't know what the briefing was, if any, and what the outcome of the hearing was.
Because there was no motion, and so there was also no briefing prior to this hearing where he held that they violated it. There was none.
Well, he could have potentially done it just based upon concessions by the government
at the
hearing that people had been moved from point A to point B, seemingly in contravention of his order that nobody be removed without being given the opportunity to file a CAT claim.
And see, crazily, I don't know if I've ever seen a judge do this. He filed something on the docket called his memorandum on preliminary injunction. He filed this the day that he had the hearing. It's 3 pages long. And it says, at today's hearing, the court found the defendants violated the preliminary injunction by failing to provide blah, blah, blah. And so he goes through his analysis for why he found that they violated the preliminary injunction.
But the government never had an opportunity to defend itself in a briefing.
Right. Yeah.
Yeah. I bet he's just going off of admissions made. I mean, the key issue in the case, as I indicated earlier, is just that the okay. Here was part of the here was part of the rub. Here was part of the rub that the government relied upon. I think in his original injunction, he used the phrase meaningful opportunity
Yes,
without
meaningful opportunity.
defining it.
Yes.
And
Yeah,
he said,
exactly.
I think he said in one of his later rulings that he purposely used that phrase to allow the exact process to sort of sort itself out over a series of cases.
Right.
What would work? Let the two sides sort out what would work and constitute a meaningful opportunity. Well, the government took advantage of the ambiguity and said,
Right.
you know,
Yes, exactly.
12
You gave them
hours,
that rope and they ran with it.
yeah,
Right. Yeah.
12 hours notice, and here's the ticket, and here's your destination. You know,
Right.
good luck. And
Then he comes back and says, "No, I think a meaningful opportunity means he's got this in bold letters, a minimum of 10
10
days."
days, and then an opportunity to consult with a lawyer. And for everybody listening, just so you know, the judge is all saying the statute says an opportunity to consult with a lawyer. You don't have the right to a lawyer in immigration deportation proceedings. In other words, the government doesn't have to appoint a lawyer for you. You
Right.
are entitled to consult with a lawyer if you can afford one, or you have a
Find
immigration
one.
rights
Right.
agency representing you.
Right.
And so the judges often order that you be given a meaningful opportunity to consult with your lawyer, and that your lawyer
Right.
have an opportunity to take action on your behalf, which builds in time.
Right. But he says also that if they're found to not have this fear of the torture, then the government must provide a meaningful opportunity and a minimum of 15 days for the guy to seek reopening of their immigration proceedings. So he's built like 25 days into this crazy procedure.
Right.
But this memo reads like a rant. And he actually put this on the docket before he issued the order. Like he went back to his chambers and slammed out this memorandum of what his thinking was on this, right? What his thoughts were. It's the craziest thing I ever saw.
I, I'm going to guess. I'm going to guess he started that the prior night. You know,
Maybe.
after he got
Yes, on the
after the
20th.
telephone conference, and he was
Yes.
told
Right.
some things on the telephone conference that made him unhappy,
Yes.
and he set it for him the next day. I bet he had his clerks pounding that thing out late into the night and starting early the next morning, and was set to go as soon as they finished with the second hearing.
It reads like first person, right? Like he personally, this is his thoughts on the matter. Which, yeah, okay, dude, you're supposed to speak through your orders, but he's new at this whole judge thing. So, well, okay, you know,
In that regard, being new to the whole judge thing, and Steve might have a comment on this if he's still around, this
he's
is an example of writing far more than you need to write to
oh
get
yeah,
done what you're trying to get done.
yeah, yeah. He's gone into the kitchen to get himself a snack, so he's not here this minute. But yeah, I agree with you. It's basically a mistake that new judges make. Is it's not what's it the style from a judge's pen should be spare. There that serves them the best, clear and spare. But you don't see too much of that anymore. King, do you want to weigh in on this? What do you make of this craziness?
I it's impossible for me to have anything to add to what we just heard. You two covered that in awesome
Oh well,
detail,
thank you.
and so I no, I don't have anything to add. I think I agree with you that the judge is pissed off and he's doing
Yeah.
his best to get his revenge.
Yeah, right. So, and sometimes a judge will do that. They often do things they shouldn't do when they let their emotions get involved. But the government seems good and mad in its pleadings to the Supreme Court, although it doesn't come across the same way. It was pretty strongly worded, I thought, from Sauer. He said that this order was indefensible. That's pretty strong language for a Supreme Court pleading. Um,
He called it
so,
in their final motion in his reply. He said
yeah,
that the defendants or the plaintiffs' reply only underscored the lawlessness of the order.
right. Yeah. I know. I mean, on the one hand, you got to admire the tenacity of these immigration lawyers, right? Like they're pulling out all the stops for these folks. So, okay, good on you for zealous advocacy. But, you know, some of their arguments are, I think, not in line with what the law actually is, which has got to be particularly frustrating for the DOJ because their main argument is that the court doesn't have jurisdiction to do any of this anyway.
Yeah, and they're
which
yeah, and they're essentially their arguments. We're just following the INA process that the Congress has set up.
Right.
And these immigration lawyers are running into district court where they don't belong and making specious claims and getting the district court judges to enter nationwide injunctions.
Right. They're getting these judges all wound up in cases where they don't have the experience and knowledge to know that I don't have any business doing this. Because they're not used to not having jurisdiction over cases that are brought in front of them. 99.9% of the time they do.
And at the district court level, especially because of what Congress did in the INA, they don't have experience in the INA procedures.
Right.
They
So it
don't do
all
them.
looks terribly unfair to them. And it's
Right.
like, oh, well, oh, tough tiddlywinks. That's what the immigration
Right,
law is.
because this is not the equivalent of a criminal proceeding where the
Right.
defendant enjoys a presumption of innocence and you
Right.
get to put the government through all the hurdles.
Right.
You know,
Right.
that's the problem with these particular cases.
Yeah.
Every one of these people has a final order of removal. They have
Right.
been through the process. And all the government is trying to do at this point is enforce the order and effectuate the removal.
Right. And so I can understand these judges that it seems unfair to them because they're used to the protections that the Constitution affords in the criminal on the criminal side. But this is a different animal. And the reason you don't know that is because the Congress has said you're not supposed to be hearing any of these.
And why?
Yeah.
Why did the Congress say that? Because district courts had ground the whole deportation process to a halt.
To a halt, which is kind of what's happening now, piecemeal, right? Because these cases are completely different from, as you alluded to earlier, the ones for the immigration enemies. I can never get that right. The enemy
It's
alien enemies act. Ah,
Alien Enemies Act.
AEA.
Yeah, where
Yeah,
you've got basically you've got a process that just drags people off the feet based on off the street based on an allegation that they're a TDA member and says you're getting on a plane tonight going to El Salvador.
right.
You know,
Bye. Right, exactly. So, right. So the judges see that and they're horrified. And it's like, well, okay. But, you know, it's not all one thing. Right. And in the criminal context, it is all one thing. You're charged under the code, the civil rules of the criminal procedure apply, right? Like the cases are all sort of on the same standing, on the same footing. These immigration cases are not. And they don't seem to be able to understand that. So, well, so you think the Supreme Court will rule?
well, I'll tell you. Here's what I'm guessing. Now, we talked about this, so this is not news to you.
Yeah, not news to me. No.
I suspect that the last opinion we're going to see. Now, apparently, tomorrow, Friday is set as the last opinion day, but they've got 10 outstanding opinions, so I think they're going to add one next week.
Right.
I think the last opinion we're going to see on the Supreme Court is birthright citizenship, but the issue before the court in birthright citizenship is the question of nationwide injunctions.
Right.
And I think that one is going to come out last. And sort of in looking at, I wrote this, I think I posted this on X. I looked back at all of the opinions that have been issued since January. And Justice Alito has only offered 3 opinions out of 50 since January. So what's he writing? Now, there's a religious liberty case out there, and he has done
Yeah.
a lot of the religious liberty cases. So I'm guessing he's got that one. But I think he's got birthright citizenship on the question of injunctions. And I think what the court is doing, and Alito's probably doing, I've seen other suggestions that it's Roberts, but Roberts has issued a lot of opinions already.
Yeah.
I think it'll be Alito. It might be per curiam that Alito does most of the work on. But I think he is also going to lay down some, we might see a change of the Winters test. Might see a refinement of the Winters test, which is, for those listening, that's the one, likelihood to prevail on the merits, irreparable injury, what's in the public interest, what are the equities. That's been in place for many years, but it's being abused. It's applied differently in different circuits. So we could see a revisiting of that and making it much tougher, particularly where
Or
the
maybe
government is.
adding some additional factors where you're seeking to apply it nationwide.
Right, and particularly where the government is the party. So
Right.
you're in effect interfering with the operations of the co-equal branch of government, um, and we might get a special injunctive test that applies only to when the
Right.
government is a party.
Right.
Um,
And
and
differentiating which would be appropriate
we've got
between cases where the government is applying a new rule as opposed to a decision in a specific individual case.
right. So we've got I don't know how many motions for stay are pending on injunctions with the Supreme Court. They've only, they acted on this one. I'm not exactly sure why they chose this one to act on, but they did. I think part of this, there's a hardship question there the government is enduring because it's keeping these individuals in Djibouti where it has a small military base. That DHS personnel are being they've been there for 30 days, and DHS personnel are being forced to rotate in and out for security purposes since the military base is not set up to be a custodial situation. These are all considered, dangerous aliens with felony criminal convictions. So so that's one of the hardship questions that the government has raised. And obviously the other side's answer is, well, just bring them back. But then you back to the chicken and egg problem.
Right.
So I think that with 10 opinions left, the dotting the I's and crossing the T's and the final edits and getting everybody to sign off on the final drafts that's joining the opinions, that's the big chore the last 10 days. And so that's where the court's time is being occupied. And that's why I think the court has been largely or significantly inattentive to dealing with some of these problems.
Right.
It just hasn't had the resources or the bandwidth while it tries to sort through the 25 or 30 opinions that it always leaves to the last month.
Which should answer John Roberts' stupid issue that he raised in the argument on these national injunctions. That yes, if we had more and more and more of these, it would take up a lot of the Supreme Court's time.
Right.
And this whole, well, we handled that one in 10 days. Oh, come on, give me a break.
Right. So I think we are likely, if Justice Alito writes the opinion in birthright citizenship and that opinion narrows the grounds for nationwide injunctions imposed against the government, then I think you'll see numerous orders come out over the next 4, 5, 6 days on these pending stays, with Alito probably writing most of them, or them just being per curiam, but Alito doing the drafting behind the scenes, since he has had only 3 cases in 6 months.
And so they'd all be basically effectively determined by that birthright citizenship case, and they'll just apply that.
Exactly. I think the birthright citizenship case will lay down the parameters, and then they might just choose to send some of them back to the circuit court for further consideration in the light of birthright citizenship, and they might decide some of them themselves.
So back to our Massachusetts case. So you think it might get caught up in that effort?
That's why I think it's 3 to 5, 7 days away from maybe getting the clarification, even though the clarification could just be 2 sentences. But you might have a situation where now that Sotomayor has done what she's done, and this district judge has glommed onto it and did what he did, you might have an Alito or a Thomas say, hold my beer, and they write a 20-page opinion going the other direction.
Right. Right. Okay. Well, the end is in sight on that case one way or another, but I don't remember if there was anything pending from the district court in the meantime, like let's say due from the parties in the next week or so. And it's kicked me off out of the case.
I think this is one of those cases where basically the merits of the case were litigated in the preliminary injunction, and it's the whole issue is what additional process, if any, is due when the country of designation is changed, and he's decided that question.
Right. Yeah. And so his procedure for implementing it may or may not be right, but he's decided the underlying legal question. that yes, they get a second bite at the apple, which might turn out to be the right answer in the sense of if the government changes the country they want to send you to, then you have a right to object to that country. Not, as the government is arguing, that, well, even though we didn't tell you that's where we were sending you, you should have raised your objections to every country where we might be sending you if you think they're going to torture you. Now, of course, no one would ever do that, and certainly no lawyer would.
I beg to differ. I think, if that was the rule, I'm not saying it should be or shouldn't be. I'm saying if that was the rule, these lawyers would have stock pleadings listing every country with a history of
Yeah, if
torture.
you made that the rule, of course.
Yeah.
But I'm saying I don't think you would independently arrive at that. Well, they want to send my guy to, I'm just making this up, Jamaica. So that's a problem for us. But on the off chance that they decide to change that and send him to Libya instead, I'm also going to talk about Libya. Lawyers don't think that way.
Well, they will if that's the rule. They will if you've got
I'm
if
saying,
the
but
rule is
okay,
you
I'm
got one
saying
bite of
if
the
you
apple.
change the rule, I agree with
Yeah.
you. But that since that's not
Well,
currently the
but I think
rule,
that could play into the calculus. It's like, hey,
yeah,
we're not talking. Well, it's like 265 countries in the world, or whatever the number is. I know it's like in the
yeah,
200s. We're not talking about France and Switzerland and
yeah,
Canada. There
right,
might be 25 that you need to be concerned with.
yeah, right. Right. But this is just not the ordinary way that lawyers conceive problems, though. If the other party is proposing to do X, you respond to that.
Right.
You don't say, oh, and by the way, let me tell you about A, B, W, and,
Yeah, but
triple Z.
the difference is litigation or immigration litigation is such a specialized practice. Everything
Yeah.
is rote. Everything
Yeah.
is the same from case to case. The client's
Right.
name changes, and the operative
Right.
facts around the client's background changes, but everything else is the same. In fact, as I've written and you've seen, the three forms of relief that you can seek after an order of removal is entered is asylum, to stay in the United States, withholding of removal. Don't send me to that country because I'm a member of a rival gang and I'll get beat up by the gang that's my rival. So don't send me that. Kilmore Abrego Garcia's. And the third one is CAT. These are so
Right.
commonly made and so commonly denied, except for the WR. There's DHS has one form. It's just a fill in the blanks form for all three of them.
You know where else you see that is in the Merit System Protection Board.
Yeah, it's the same
Right.
stuff. You got to
The
process
form
thousands of
there.
cases a year.
Right. Exactly.
If every pleading started from scratch, it'd be
It'll be
unbelievably
completely
expensive.
unmanageable.
Right.
Yeah. Completely unmanageable. Yeah. So, okay. Well, I don't know how this case is going to turn out, but I suspect that the Supremes, the majority of them, are not going to think that that remedial order is worth the paper that it's written on, one way or another.
Well, I think one of the reasons they probably didn't write this is just reading between the lines and just pure conjecture and supposition on my part, and in some ways infers bad faith on the sixth justice's part. But I think one of the reasons why they decided the way they did and the reason they didn't write was just who these 8 guys are. It's like,
Right, because they're all rapists and murderers and
exactly, we
child
are
sex
torturing the
offenders.
system
Right,
over 8 individuals who have no entitlement to torture the system.
right, right. So now that's not supposed to be the
It's not
guiding
supposed to be, but
principle. Right, right. So. But, and as a defense lawyer, I often had to remind a judge that, okay, but you're not making rules for the guiltiest. You're making rules that you're going to apply to people who are actually innocent. And is that the way you would apply it if you thought the guy was innocent? This is supposed to be the way principles operate. So, but I agree with you that at this stage, I'll probably think, we can't be bothered with this. Let the First Circuit sort it out. But, I wonder, do you think that they knew that we were holding these guys in temporary coolers in Djibouti? The Supremes ship? Do you think they realized that?
yeah, the government's application for stay is 40 pages long, and the defendants filed a long opposition. All of those facts are before the court.
Were they though? Because didn't that happen after?
That they got shipped to Djibouti. Oh, you're right. You're right.
Yeah.
No. They've been shipped already.
Okay.
This happened. They filed May 27th. They filed a month ago, and it was after they got shipped to Djibouti because that's what pissed the judge off.
Right.
That led to that May 20th and May 21st back-to-back hearings, where he found them in contempt for moving them
Yeah.
without giving them the process.
Well, he didn't find them in contempt,
Or not
but
contempt.
he
He
basically did.
violation of the
Right.
preliminary injunction.
Yeah. Yeah. Okay. Well, because then that would argue for the yeah, the Supremes would think this remedial order was also quashed by their stay.
Yeah, I think when they line the remedial order up with the injunction itself, and what the injunction told the injunction didn't tell the government what it couldn't do. It told the government what it had to do.
Had to do. Right.
So when you line the remedial order up with the terms of the injunction, they're the same, or effectively the same.
Yeah. Yeah. It's effectively the same. Yeah. Right. So, okay. Well, if that's going to be the result there, that's going to at least make sense. And they're just hung up on this technical point that Sotomayor raised that, well, but you didn't appeal that, which is true. They didn't.
Well, again, though, if words
Mm,
matter, this isn't an appeal;
yes.
it's a motion to
Right.
stay.
Right.
It's
It reminds me of, I saw in the press recently this case where the Supreme Court of a state, maybe Alabama, um, said it was unconstitutional to require schools to have the Ten Commandments in every courtroom, right? And so the parties' lawyers, the lawyer for the state and the lawyer for the people who were objecting to this, were arguing in the press about whether that then applied to school districts outside of the districts that were in the lawsuit, right? And
Yep.
so they were confusing the issues of if the state Supreme Court rules that a state statute is unconstitutional, it doesn't matter if you're part of the lawsuit or not. Like that statute is struck down. It's not enforceable in the
Well,
state.
that's a question that's at issue in the birthright citizenship case.
Yeah, exactly. Yeah. So, which is different from our question about, well, how far does the injunction go, right?
Right.
So, that's a different issue. So, yeah, same thing is in play in this Massachusetts case, right? Does the Supreme Court stay cover every order that it substantively applies to, or only the ones that you literally appealed? It's a similar kind of, you could, frame it either way. But I do think the better argument is that the one you just said. If you line the two orders up, they're substantively the same, and so the Supremes don't have to say, "Oh, and also your May 21st order is also out of here." Um, but
The issue in effect is enforcing the preliminary injunction. Whether you
yeah,
enforce it as it's originally written or
right,
you enforce it with a remedial order, it's the same thing.
right. Yeah, and so people are going to ask because they're not going to understand. So let's address this point, and then we'll be done for tonight. Which is, how can if the judge doesn't have jurisdiction of the case, how can the preliminary injunction be enforced anyway? So the rule is, if a court doesn't have jurisdiction over you, then it can't order you to do things. Okay, but the courts also say that if the court is trying to figure out if it has jurisdiction over you or not, then it does exercise temporary jurisdiction of you while it sorts that issue out. So you don't have to obey an order that a judge doesn't have authority to impose on you, but that's different from the judge got it wrong and made the wrong ruling. So here, this district judge asked them whether they thought he had jurisdiction. And he asserted this principle that while he was figuring out whether he had jurisdiction, he does have jurisdiction. And I agree with that rule, but that doesn't change the fact that ultimately, if the judge doesn't have jurisdiction, then whatever it was he ordered you to do, you can't be held in contempt for not doing. But there is some debate on that last point, right? So some of the judges will say, well, because it was pending at the time, even if I didn't have jurisdiction to order you to do it, I can hold you in contempt for it anyway. And I don't agree with that point. So I don't think we're going to get into that particular issue with this Massachusetts case because he seemed to have concluded that he did have jurisdiction. I think he's wrong about that, but
Right.
yeah.
All right, we've been at this 3 hours. I think it's
Yep,
time to go.
I agree. Steve has already gone off to our room, so he's done for the night for sure.
King's been awfully quiet. He might have too.
Did you fall asleep?
I've been dozing off and on, and my mind had went off on a tangent listening to y'all, and I have something for you to think about over the next few days.
Okay.
Since in the Maryland case is in federal court, it's a civil lawsuit. The federal rules of civil procedure apply. Uh, does that make the uh, uh, applicants for writs of habeas corpus in that court necessary or indispensable parties to that suit? And do they have a right to
Oh
intervene
my.
to protect their rights?
This is a
And then
Rule
do you
19 question. Yeah.
and then do you have a situation where co-defendants would be not only the judges but the
But all
uh,
of the
all
immigrants
of
too.
the immigrants, yeah,
Oh my
who are
God.
seeking who are banking on that temporary
Yes. I
injunction
mean, they
to
obviously have an interest. So,
absolutely.
okay. So, in the rules of civil procedure, there's a rule, it's 19, that deals with necessary parties. And actually, Steve argued a Rule 19 case in the Fourth Circuit a couple months ago. So, we can debate that question, but we'll need him for that. And he's already gone off to bed. So, we'll have to
To me,
postpone it.
it's just further proof of the
Yes.
insanity.
Right. It's further proof of this is not a case, actually. The way you've positioned it, no, this is not a case. I didn't expect us to come out there at the end, did you guys? That the DOJ really, this is not a proper lawsuit.
Yeah.
I thought it was performative from the start.
What a cynic you are. Okay. All right, guys.
Well,
Well, as you say,
but like I
enough.
said, I think it's return fire.
Yes, it's
You know,
return fire. I
if
agree.
they did this unprompted by anything over the past 5 months, that'd be a different story.
Yeah. Right. It does have the odor to it of we've had enough.
Yeah,
Enough is enough. Yeah.
particularly with the court that they picked.
Yeah.
You know,
Well, the court has left itself open to this argument by issuing this standing order, right?
right,
The whole
right. They wouldn't. The court opened themselves up to this.
Yeah, they did. Yeah. So, okay. All right, guys. Well, thank you as always. And I'll say good night.
All righty.